Ask him if you can allow it. Ask him if you can allow it.
What about the delay? IA.
I have 36 days delay for filing
Yes.
this.
Speak out.
In the meantime, delay may condone matter may be fixed for admission hearing.
Lordship, my problem is that the petitioner is posted in Chirang. And for that reason, he is unable to give us instruction by coming to one. So kindly give us.
No, it's only 36
Yes,
days
at
delay.
least after 1 week, the delay may be condoned. After, let me get some instruction, Lordship.
On the prayer of the learned council for the parties, list this matter after 1 week.
That's all.
May it please your lordships. Lordship, I beg to mention item number 7 of today's daily list, lordship. I'm appearing on behalf of Miss R.D. Mujumdar. She's the amicus curiae in the case, lordship. She's out of station, gone to Nagpur, lordship, for imparting mediation training program. Lordship, after a week, next week, lordship.
Okay. Mediation.
MS,
C.
What's-
Mujumdar, lordship.
so
C.
it's
Mujumdar, on behalf of R.D. Mujumdar.
learned council appearing on behalf of MS R.D. Majumdar, learned amicus curiae, praised for and granted 1 week's time.
Lordship.
List this matter after 1 week.
Much obliged, lordship.
May I please, your lordship? No, I beg my lord's pardon, my lord. Item number 8, my lord. It's a hearing matter. What has happened, my lord? The applicant number 1, he has engaged Mr. P.K. Muni, my lord. And the matter has come over hearing, my lord. We have not received the paper book for 2, 3, and 4, my lord. The office notice, my lord, 26/5, my lord. We were initially for all 4, my lord. Now, my lord, for 2, 3, and 4, my lord. Any 3 days time may be granted for the IAS come up for hearing, my lord. We'll collect the paper book, my lord, and
In that case, after 2 weeks,
any day. Yes, my lord.
Mr. So
And Mahajan.
learned council appearing for
Appellant number 2, 3, and 4 in criminal appeal 47 or 22. my lord.
respondent number 2, 3, and 4.
Well, appellant,
For appellant.
appellants, my lord.
There are
There are total 4, my lord.
4 appellants.
One is by another.
Okay. Appears for appellant number
2, 3, and 4, my
2, 3, and
lord.
4
My lord.
and submits that he
We
has
have
not received the
my lord.
paper book. Paper book.
Paper book, my lord.
Mr. Accordingly, the registry to furnish the paper book to the learned council for the appellant.
My lord.
List this matter after 2 weeks.
Highly obliged, my lord. Obliged, my lord.
Because next week we are having this 15th. That's very difficult. Daily list item number 4 for hearing.
Met visual. Here the appellant is in jail for last 6 years, 4 months, Lordship. And he was convicted under section 302. Here, Lordship, the deceased was his son-in-law.
This is a sentence first. And then this is. Here this is happening. Yes. It should be. But this happens. Let me check it.
Identifying with the same thing and we know.
No, but if it is not there, we have to call for this section people and tell them. Yeah. Because here it is 23. But they should put it below this. This is 1. This should be 22. So we should have come back last. Yes, suffered installation now till now for how many days?
6 years, 4 months.
6 years, 4 months.
Years, 4 months, 18 days. The FIR, your Lordship will find page 4. Married.
Then ask him to start.
Here, Lordship, the victim was Jan Bora, and he was missing from 13/3/2017. And thereafter, on 17/3/2017, one missing report was filed. And thereafter, dead body was recovered, and on 22/3/2017, at about Lordship 12, and thereafter on the same day FIR was lodged after recovery of the body without head, Lordship. FIR was lodged by the ASI, and your FIR, your Lordship, will find page 4. In the FIR, 2 persons are named, the appellant and his wife, Anita Biswas. And after trial, she was acquitted. And in the charge sheet, your Lordship will find the son of the appellant was also shown as an accused, and his case was transferred, sent to juvenile board, Lordship. And regarding that, what happened in that case, whether it is filed or any the order is passed, that is not there in the record, Lordship.
Okay.
Dibjyoti Biswas. FIR, your lordship will find page 4. Humble submission is that in connection with the aforesaid entry of Koliabor Police Station on 17/3/2017, Sri Juma Bora, wife of Jan Bora, residents of Gumutha Gaon, informed by lodging a written azahar that her husband Jan Bora had been missing since 13/3/2017 and his mobile phone was switched off. In course of the investigation of the case, the partially decomposed headless dead body of Jan Bora was found in Kolong River that flows along Koliabor at about 11 a.m. on 22/3/2017. After the inquest on the dead body being held by Executive Magistrate Rituparna Borua, it was sent for postmortem examination. During the investigation, it could be learned that at about 7 p.m. on 13/7/2017, Jan Bora, residents of Gumutha Gaon, PS Koliabor district, Nagaon, smeared in color of holy, went to the house of his father-in-law, Krishna Biswas. In Krishna Biswas' house, a quarrel took place over the issue of money among Jan Bora, Krishna Biswas, and Sri Onita Biswas, resulting in a fight among them. Krishna Biswas attacked on the head of Jan Bora with a branch of tree, whereupon Jan Bora fell down on the ground and died at the place of occurrence itself. Now, here your lordship may kindly note that initial case was that the appellant hit him in the head and he died on the spot. That is contrary to postmortem report. Therefore, I am pointing out here.
The allegation the initial allegation was that he was hit by a branch of a tree.
Branch of tree. And he died on the spot.
Died, then he died.
Died.
And then the dead body was disposed of. Then, but the head is now found severed.
Later, Sri Krishna Biswas dragged the dead body to Kolong River with the help of wife Onita Biswas and threw it into the river and covered it with Meteka water hyacinth. They beheaded the dead body by cutting with a knife and kept the severed head near the body and thereafter covered it with water hyacinth. After the recovery of the dead body today, the severed head was searched as shown by the accused, but it was not found. On the basis of the confession of Krishna Biswas, the knife used for cutting the head was recovered from his house, and the same was seized in presence of the witnesses.
No. Miss Jahan, you are looking at the LCR.
Lordship, yes.
Please see that memo of leading to discovery is there or not.
Lordship, yes. Whether that statement, 161 statement,
No. Leading to recovery
that is
must be preceded by an entry.
leading to recovery of the body.
That-
And otherwise 161, that recovery leading to discovery is also there.
In 161.
Part of the 161 of the accused.
Okay.
That is exhibited,
Okay.
that is there.
That is exhibited also.
I can see the translated part.
Okay.
Perhaps exhibited.
No, but in that statement, there is nothing that he will show the accused the place where the head was there or the knife was there. That part
I don't know.
not
This is something I did not notice. That's why I'm asking.
there. That part is not there.
Okay.
So thereafter, this FIR was lodged against two persons, the appellant. Now your lordship may kindly turn to page 10. That is the evidence of the informant, that police officer. In the FIR, just one more thing I'm pointing out that regarding that knife or recovery of knife, it is already mentioned in the FIR. So before the FIR was lost, the knife was recovered. In page 5, your lordship will find first paragraph, last two line. On the basis of confession of Krishna Biswas, knife used for cutting the head was recovered from his house. So prior to FIR, the knife was recovered. Because their case is that when my 164 statement was recorded, and thereafter I led them to recover those articles. Page 10, the statement of informant. On 17/3/2017, I was posted at Koliabor Police Station as ASI of police. On that day, we got a written information from one Juma Bora, wife of Jan Bora village Gumutha, that her husband had been missing from 13/3/2017. And his mobile phone was switched off. On the basis of the written information and GD entry by Koliabor PS GD number 316 dated 17/3/2017 was made by the OC of Koliabor Police Station, Sri Rajen Bora. Exhibit 1 is the GDE and Exhibit 11 is the signature of the OC Rajen Bora, which I know. In course of investigation of the case on 22/3/2017, at around 11 AM, the dead body of Jan Bora was found at Kolong River near Koliabor. The dead body was recovered with its severed head in decomposed state as Kolong River near Koliabor. The executive magistrate Sri Rituparna Barua made inquest on the dead body. Then the dead body was sent for postmortem examination. During investigation, it is found that immediately before the occurrence, Jan Bora had a quarrel with his father-in-law Krishna Biswas and mother-in-law Anita Biswas at their house. The accused Krishna Biswas assaulted Jan Bora on his head with a branch of tree, as a result of which he fell down and succumbed to his injuries. The occurrence had taken place in the homestead of the accused, which is situated on the bank of Kolong River. Thereafter, accused Krishna Biswas and his wife Anita Biswas dragged away the dead body of Jan Bora and threw the dead body at Kolong River. Thereafter, they covered the dead body with meteka. They also severed the head of Jan Bora by cutting with a knife and covered the head with meteka. During the course of investigation, the OC of Koliabor Police Station, Sri Rajen Bora, took both the accused persons in custody, and on the basis of their statements and on being laid by them, the dead body of victim Jan Bora was recovered from Kolong River under meteka. On being shown and laid by Krishna Biswas, the knife used in the crime was recovered from nearby his house, and the same was seized in my presence. I was present at the time of recovery of the dead body and the knife. On 22/3/2017, I lodged the Ejahat at Koliabor Police Station. When the accused were taken into custody by the OC before leading to the discovery of the dead body of the victim and the knife, he recorded the statement of the accused person under section 161 CRPC. Exhibit 2 is the Ejahat. Exhibit 21 is my signature. Cross-examination by defense. The application which Juma Bora lodged at Koliabor Police Station regarding missing of her husband and then his mobile phone was found switch off is not available on record. This is regarding that entry in the GD entry, where it is said missing report was lodged. And normally whenever any information is given, that is given in writing. And they have not said that oral information was given. So therefore, the specific question was put whether any application was there from wife or not. He said there was no record of that.
No, so GD entry means anything which has come to the knowledge of the police
Knowledge of
station.
Yes.
It may be oral, it may be written.
It is oral or written, but they have not said it is oral. Therefore, this question probably was.
It's okay. This thing doesn't matter much. Unless it's a contradiction which materially affects.
Yes.
Because here what had happened was the man went missing on 13.
Yes.
Then first the severed head was recovered. Then the body was recovered after 9-10 days.
Right.
6-7 days the head is recovered.
Right.
After 9-10 days the dead body is recovered.
No, first dead
30
body was recovered. They say on the next day head was recovered. But
Okay.
from the evidence your lordship will find on the same day it was recovered before lodging of the Ejahat. I will place before.
No, that is okay. But only then the Ejahat was lodged on 22nd.
Yes,
So 22nd means after the entire body was recovered.
yes.
So then it was mentioned. So it is quite possible that statement leading to recovery
Right.
can precede the FIR in this case.
But in the FIR, it is not mentioned that the head was recovered. In the FIR, it is not mentioned. That is what I am pointing out, that there is something in the investigation, and therefore I am pointing out this part also. Exhibit 2 Ejahar was written by me. Exhibit 2 Ejahar was lost after recovery of the dead body and the knife used in the crime. At first, the dead body was recovered during the daytime at about 12:30, probably 1 p.m. and knife was recovered at 1:30 p.m. The IO did not ask me about the occurrence. At the time of recovery of the dead body, I was present. Other public were also present at the time of recovery of the dead body. The IO recorded their statements. The IO of the OC of Koliabor Police Station, namely Sri Rajen Bora, being the IO, contacted the executive magistrate to perform inquest on the dead body of the victim Jan Bora. At the relevant time of recovery of the dead body and the seizure of knife used in the crime, Gajen Bora, Joykanto Bora, and Kamal Bhuya were present. The wife of the victim stated to me that on 13/3/2017, her husband was missing and he came to the house of accused Krishna Biswas. On the basis of the information received from accused Krishna Biswas, I mentioned in the Ejahar that on the relevant day, his son-in-law, Jan Bora, visited his house, and upon quarreling with Jan Bora, he assaulted his son-in-law, Jan Bora, on his head, and he died in the spot. At that time, I was present. I have not seen the seized knife before this court today. The seizure of the knife was, the seized knife was 6 inch.
Size of the knife.
Yes, the size of the knife was 6 inch in length. The accused persons during police custody and before recovery of the dead body stated before us that they, having murdered their son in Angora, dragged and threw the dead body at Kolong River, severed the head from the body and covered with meteka. At first, the dead body up to the neck was recovered, and then the severed head was recovered. The severed head was found at about 3 p.m. on the same day. But after lodging the Exhibit 2 Ejahar, in Exhibit 2 Ejahar, I have not mentioned that I was all along with the IO during the recovery of the dead body, the severed head, and the seized knife. I do not know when the IO arrested the accused persons. The dead body was recovered at a distance of 1 furlong away from the house of the accused person. There are houses of other persons behind the house of the accused person. There is also poultry farm. I do not know if there is any employee of the poultry farm. The accused persons and one constable, Padma Bora, identified the dead body of Jan Bora. Subsequently, the wife of the victim came to the place of occurrence and identified the dead body of Jan Bora. In my Ejahar, I have not stated that the wife of the victim identified his dead body. The police department did not take photograph of the dead body. I did not observe any blood stain on the seized knife. The police, during the recovery of the dead body, at the instance of the accused persons, did not state that the accused persons had committed the crime. It is not a fact that Exhibit 2 Ejahar is based on imaginary story. It is not a fact that I tried to mislead the court by suppressing the actual fact. It is not a fact that I was not all along with the IO during recovery of the dead body and other articles. It is not a fact that the dead body was not recovered as per the information and laid by the accused persons. Now, PW2, page 13. I know both the accused persons standing in the dock of the court today. My house is at a distance of about 1 kilometer away from the house of the accused persons. I know the complainant Sri Pinaki Acharya, ASI of Koliabor Police Station. I also know the deceased Jan Bora, whom I address as Dada, elder brother. The occurrence had taken place during the night of Fakua of the current English calendar year. On the relevant night, Jan Bora became missing. After 10 days, the dead body of Jan Bora was recovered in the Kolong River on the backside of the house of accused person. Dhan Bora, the younger brother of deceased Jan Bora, with the villagers, noticed the dead body of Jan Bora in Kolong River on the backside of the house of the accused persons and informed the police. Now, this part, Lordship may kindly see that Dhon Bora, who initially discovered the dead body, but the PW1 saying that appellant led the police to recover the dead body. Police went to the spot. Thereafter, I also arrived there. The police, with the help of sniffer dog, discovered the wearing chappal of the Jan Bora nearby the dead body. One rope was also found near the dead body. The sniffer dog also, after getting the smell of the chappal of the deceased, straightway went to the house of accused persons and recognized one sandal box in the house of the accused persons. In the meantime, police had already arrested and taken custody of the accused person before taking the sniffer dog to Kolong River on the backside of the house of the accused persons. The dead body of Jan Bora was found at first without his head. On the next day, on being laid and shown by the accused Krishna Biswas in our presence, the head of Jan Bora was recovered at a distance of 3 meters away from the place where his dead body has been recovered. Now, this part, along with the evidence of PW1,
It was
PW1
recovered on
says
same day at 3 p.m.
3 p.m. The head was covered with pani meteka on the river on 14. The dead body and head were almost starting decomposing. Dhon Bora identified the dead body of his victim, elder brother. As per instruction of police, I made audio and video recording of the statements of Krishna Biswas and his wife in presence of witnesses, and they confessed the crime. After preparing the cassette, I handed over it to Koliabor police station. Police prepared the seizure list and I put my signature on the seizure list. I went to see the dead body only after coming to know that the dead body had been noticed in the Kolong River on the backside of the house of the accused persons. At first, I made video recording of the statements of the accused persons through my mobile phone, and thereafter the cassette was prepared by me in presence of the OC of Koliabor police station. Thereafter, in my presence at the court, and I found it to be genuine and correct. There is a recent Supreme Court judgment where it is said that videography of that scene is not have no evidentiary value. Also. There is a Supreme Court judgment
What does it say?
that videography, when it is the scene is recreated, or regarding that leading to discovery, when it is videographed, that video evidence or evidentiary value of that videograph is not there.
No, but this is not that. This is the recording of the statement of the accused
Yes,
in video.
yeah,
That is admissible.
now, that part your lordship will find later on that he admitted that there is a chance of manipulation.
Wow.
That part is there. Police also seized my mobile phone, by which initially I made video recording of the statements of the accused persons, and later on police handed over my mobile phone after preparing the video cassette. Exhibit 4 is the seizure list and Exhibit 4.1 is my signature. Cross-examination by defense. I passed higher secondary in arts stream. I got training in hardware and software computer working from Jain Computers in Tezpur. From a mobile video recording, a video cassette may be prepared with the help of laptop. The audio video mobile recording of the statements of the accused with the help of my mobile phone was done in the campus of Koliabor police station. At that time, the other persons and police personnel were present. The audio recording of the sound of the person may be made video recording with the help of another person by tampering the process. This is there. My house is at
No, that is a general statement.
Lords.
That is a general statement. It's not a contradiction.
The possibility is there.
No,
Because
that's
here
okay.
65B certificate is not there.
That is separate, but independent of everything, if only this question is asked,
Lords.
then I may ask a witness a question whether somebody can be hit by a car and can he die? He will say yes.
No, here, Lordship, what in my understanding, limited understanding, Lordship, This question was asked because there is no certificate under section 164(5)(b).
No, that is
of
okay.
ITI.
That is okay.
Therefore, that
Independent,
question
I'm
was-
saying independent of everything.
Yes. because
If only a
they have-
standalone question is asked,
Lots.
and if the answer is positive,
Right.
it's merely indicative of something which can happen.
No, in circumstantial case, Lordship, in my understanding, they have to prove the case beyond reasonable doubt. And when they say about this, they have to prove it that it is genuine.
You're right, 65B can't be
There is
dispensed
a
with.
chance of tampering and they have not produced the certificate under section 165B. My house is at Kuarital, which is at a distance of 5 miles away from Koliabor police station. At the relevant time of recovering the dead body, about 150 people were gathered. The family members of Jan Bora and persons of the village were present there. At the relevant time, Juma Bora, the wife of Jan Bora, was not present. Police recorded my statement before and after preparation of material exhibit A audio video cassette. I was present when the dead body of deceased Jan Bora without the head was recovered, but I was not present when the head was recovered on the next day. When the police recovered the head of the Jan Bora on the following day, I was also coming towards the place. It is not a fact that material exhibit A was not prepared by me as per instruction of police. It is not a fact that material exhibit A is not the voice and image of the accused person. So here he has directly crossed this on this point. It is not a fact that dead body which was recovered in the Kolong River was not of deceased Jan Bora. One long pen was found on the dead body of Jan Bora. The dead body was found upside down, sitting on the river water. I could recognize the wearing dress of Jan Bora, which was found on the dead body. On the relevant day prior to missing of Jan Bora, we were playing Holi with him for the whole day. I came out in front of Madhav, then after playing Holi at 2:30 p.m. on the relevant day. As there was no photographer, police engaged me for making audio video recording of the statements of the accused persons. PW3, page 16. He is brother of deceased. I know the accused person standing in the dock of the court today. They are from our village. I know the complainant Acharya of Koliabor police station. The deceased Jan Bora is my own elder brother. The occurrence took place in the evening on 13/3/2017. My elder brother Jan Bora became missing from our house. We started searching him at several places. After inquiry, we came to know that my elder brother Jan Bora had come to the house of his father-in-law Krishna Biswas in between 7 p.m. and 9 p.m. on 13/3/2017. The next day was Tuesday. On that day in the morning, myself and my two friends who were also tempo drivers came to the house of the accused Krishna Biswas and inquired about my elder brother Jan Bora. When I asked accused Onita Biswas, the mother-in-law of my brother Jan Bora, she replied that he had visited their house on the previous date and after collecting money from her, he had left. When we returned, the neighbors of the accused persons told us that a noisy situation was created at the house of accused persons on the previous night. Then suspicion arose in our mind that something might have happened to my elder brother Jan Bora. There being a big jungle by the side of the Kolong River, our family members and all the villagers started searching my brother in the jungle. After 7-8 days of missing of my brother, his beheaded dead body was found in Kolong River, which was covered with metega. From the physical appearance and wearing clothes, I could identify that it was the dead body of my brother Jan Bora. When we were searching our brother, two police personnel were also with us. One chappal and one rope were found near the dead body. Police brought sniffer dog. The sniffer dog took the smell of the chappal and the rope nearby the dead body, and then the sniffer dog straightway went to the house of the accused persons. Villagers, police, and other persons followed the sniffer dog to the house of the accused persons. Thereafter, police arrested both the accused persons and their son. My sister-in-law, wife of Jan Bora, was staying at our house at the relevant time of missing in the evening of 13/3/2017. Only after 3 days of occurrence, she came to the house of her parent, the accused persons, to inquire about her husband, Jan Bora. Then she again returned to our house. Police interrogated the accused persons at their house as well as at the police station. During that period, I, along with other persons, were also present. Immediately after arrest of the accused persons by police, they stated that they had killed Jan Bora at their own house within 7 p.m. to 9 p.m. on 13/3/2017. Here your lordship will find that they are alleging that both husband and wife confessed. Subsequently, that also changed. On the next day of the arrest of the accused persons at about 9:10 a.m., accused Krishna Biswas stated before police that after killing Jan Bora, he severed the head of Jan Bora and kept concealed by covering with meteka at a distance of about 10-15 feet away from the place where the dead body was found. Accordingly, in our presence, the accused led the police to Kolong River and himself fished out the severed head of Jan Bora, which was concealed in the water by covering meteka. At that time, we were all along present. The above statement was made by Krishna Biswas in my presence before discovery of the severed head of my brother Jan Bora. Thereafter, the severed head of my brother was brought to Koliabor police station. Before discovery of the severed head of my brother on being laid and shown by accused Krishna Biswas, he stated in front of police and us that he had severed the head of my brother by cutting with a cautery knife. After recovery of the head of my deceased brother, accused Krishna Biswas came to the house and showed the cautery knife inside his house with which he committed murder of my brother. Police seized the cautery knife in our presence from the house of accused persons. I put my signature in the seizure list. So further cross was reserved. Page 19, your lordship will find further cross examination. In examination in chief, lordship, page 19. After smelling the chappal and one plastic rope at the place of occurrence, the sniffer dog straightway went inside the house of accused. Police and we also followed the sniffer dog inside the house of the accused. Police seized the plastic rope and one chappal from the place of occurrence in my presence. Exhibit 5 is the seizure list. Exhibit 5(1) is my signature. Material Exhibit B is the chappal and rope which police seized from the place of occurrence in my presence. Chappal belongs to Krishna Biswas. Police arrested the accused persons after seizure of the chappal and plastic rope. Police recorded my statement during investigation. Deceased Jan Bora, being my elder brother, was also residing in our joint family along with our parents. My parents are alive and living with me. My deceased brother Jan Bora was involved with social work. He used to work as daily wager. On the day of occurrence, there was Holi festival. On the relevant night of occurrence, I came to know that my brother Jan Bora was missing. We informed regarding missing of my brother Jan Bora at Kuoritol police station. I do not remember whether any written azahar was lodged regarding missing of my brother Jan Bora at Kuoritol police station. On the following morning, police came to our house. Police asked me about my brother and as to when he became missing. On the following day of missing of my brother, when police came, no sniffer dog was brought. After 8-9 days of missing of my brother Jan Bora, his dead body was recovered. By this time, I lodged written FIR at Kuoritol police station. I got drafted the FIR through a clerk of SDO office, Koliabor. My brother Jan Bora used to live in the same house, but it is in a separate room adjacent to my room. But no FIR filed by him was executed. On the next morning of missing of my brother Jan Bora, police recorded my statement. The house of Arun Soikia is at a little distance from our house on the left side. There is no house of any person except our house and the house of Arun Soikia. There is a distance of 50 meters between our house and the house of Arun Soikia. Onita Biswas stated to me that on the day of Fakua, my elder brother Jan Bora had visited their house in search of money when I visited their house on the same day of Fakua. This fact I stated to our family members. I also stated this fact to the police of Kuoritol police station. I orally informed this fact to the police. The wife of Jan Bora came to her paternal home after 3-4 days of missing of her husband. It is not a fact that in my previous statement before the IO, I did not state that on the next day of missing of Jan Bora, when I went to the house of accused persons, Onita Biswas stated to me that Jan Bora had come to their house to collect money. I know that the accused persons and their son stayed at their house. Besides them, I do not know if any other person resides with him. On the date of recovery of dead body, I visited the house of accused persons. In between the next day of missing of my brother Jan Bora and recovery of his dead body, I did not go to their house, although I searched him nearby the jungle. So he's saying, Chief, that he went there, he was informed that he came and lived. But here your lordship will find, he stated that from the date of missing till recovery of dead body, he never gone there. There are houses of other persons nearby the house of
So just
accused.
show me that contradiction.
In page 16, your lordship will find in middle portion, from bottom 1, 2, 3, 4, 5, 6 lines. When I asked accused Onita Biswas, lordship, the mother-in-law of my brother Jan Bora, she replied that he had visited their house on the previous day, and after collecting money from her, he had left. But here in cross-examination, first your lordship has seen that it is not a fact. Second line, page 21. Second paragraph, page 21. It is not a fact that in my previous statement before the IO, I did not state that on the next day of missing of Jan Bora, when I went to the house of accused person, Onita Biswas stated to me that Jan Bora had come to their house to collect money. So it was not in 161. And now this and third paragraph, lordship, fourth line, that starts with persons in between the next day. In between the next day of missing of my brother Jan Bora and recovery of his dead body, I did not go to their house, although I searched him nearby the jungle.
The next thing, let's see.
It says in between the next day of missing.
Yes, because he was missing from 7 to 9 p.m. Previous day. So at night he did not go. That is admitted. That is
Next day,
next day
he went, but it says in between the next day of the missing.
Yeah, there,
If we
probably
correctly
my
read
understanding is that in between will be also there from the date
No,
of
no,
missing
next
from
day.
the
next
date.
day, it says
Lordship.
from the next day of the missing. He
In
went
between.
to next day to the accused place.
Lordship.
But then here it says, if we correctly understood, in between the next day of the missing.
But apart from that, in paragraph 2, he admitted that he has not stated before police regarding that.
But then, so far as your
Lordship.
contradiction,
Lordship.
I'm trying to point out.
No, I was
He
reading.
went in next day of the
Lordship.
missing, But in between the next day of the
I was
Missing.
trying to connect the both lines, that paragraph 2 and this paragraph.
Okay,
The three houses of other persons nearby the house of the accused persons, but I do not know the name of the neighbors. On the next day of Fakua, when I went to the house of Onita Biswas, I found Onita Biswas and her other neighbors, but I do not know their names. It is not a fact that in my previous statement before the police, I did not state that the neighboring people stated to me that a noisy situation was created in the house of the accused persons on the previous night. At the time of recovery of the dead body, 2 police persons were present, but I do not know their names. When I accompanied by the villagers went to trace out my brother Jan Bora, 2 police persons were with us. At first, I saw the dead body of my brother Jan Bora under Meteka with his head severed. At that time, the dead body started decomposing, but it could be recognized. I also could recognize the clothes on the dead body to be of my elder brother Jan Bora. The head was found on the next day. The dead body was found on the daytime at around 11-12 o'clock. One inner garment and a shirt were seen worn on the dead body, but I cannot remember whether it was a t-shirt or full shirt. I also cannot remember the color of the cloth. One jeans pant was also found on the dead body. On the same day of the recovering the dead body, police sent it to Nagaon BP Civil Hospital for postmortem examination. The dead body with head severed could be identified by clothes to be of my elder brother Jan Bora. I could recognize the dead body as he was my he was my brother. Apart from the injury on the neck, I did not notice any other injury on the remaining part of the body. It is not a fact that the dead body was severed head was not of my brother Jan Bora. One rope and one chappal were found nearby the place where the dead body was found. It is not a fact that chappal and rope were not found. It is not a fact that 2 police constables were not with us at the time of recovery of the headless dead body. It is not a fact that I did not state before the IO that 2 police constables were with us at the time of recovery of the headless dead body. After the magistrate visited the place where the dead body was found, after about 3 hours, the dead body was taken to the police station. Till the police brought the sniffer dog, I was at the place where the dead body without head was recovered all along with the other persons. At the time of recovery of the dead body of my brother Jan Bora, Krishna Biswas was at his house and did not come. Police arrested him on the same day from his house, but I cannot remember the exact time when Krishna Biswas was arrested by the police personnel. I cannot give the exact time when Krishna Biswas was brought to the police where the dead body without head was recovered. After the dead body was found, the sniffer dog was brought. The sniffer dog was smelling the chappal and rope when led the police to the house of accused persons, and then he was arrested. On the next day of recovery of the dead body without head, the Krishna Biswas was brought by police from the police station to the place. The sniffer dog came on the day of recovery of the dead body without head. It is not a fact that the sniffer dog did not lead police to the house of Krishna Biswas. It is not a fact that police did not arrest Krishna Biswas from his house. From the house of Krishna Biswas, the sniffer dog was brought by police. I do not know from where the police took the sniffer dog. It is not a fact that the sniffer dog did not go nearby the dead body. It is not a fact that material exhibit B, rope and chappal were not found nearby the place of occurrence where the dead body was recovered. It is not a fact that I did not state before the police that rope and chappal were found at the place of occurrence. It is not a fact that sniffer dog did not go to the house of Krishna Biswas. On the next day of recovery of the dead body, at around 9 to 11 a.m., the head was recovered by police on being led by Krishna Biswas that time, the police and Krishna Biswas accompanied. The head was shown by Krishna Biswas. At that time, police accompanied him. On the previous night, Krishna Biswas was at the police station and head was recovered on the next day. It is not a fact that Krishna Biswas did not show the head of the deceased Jan Bora to police in our presence. It is not a fact that I, in collusion with police, falsely stated that Krishna Biswas had shown the head of deceased Jan Bora. It is not a fact that in my previous statement, I did not state that Krishna Biswas confessed that he had killed my brother Jan Bora. It is not a fact that the head was not of my brother Jan Bora. At the time of recovery of the head, the eyeballs were not there. It is not a fact that I could not recognize the head to be of my brother Jan Bora. It is not a fact that the head was not in identifiable position. The nearby area where the dead body was recovered in a jungle is a jungle. There are big and small trees. As it was recovered by Kolong River, there were branches of trees falling in the jungle. It is not a fact that my brother Jan Bora had gone to the jungle to collect firewood as a wager. It is not a fact that I did not have any suspicion upon Krishna Biswas. It is not a fact that Krishna Biswas did not commit murder of Jan Bora, nor he led the police to recover the severed head of the dead body. I cannot say whether my brother Jan Bora had excessive drink on that day of Fakua. It is not a fact that I am deposing falsely. Now,
This, what is the relationship between this Krishna Biswas and Anita Biswas?
they are husband and wife,
They are husband and wife. So
Husband
this
and
is his father-in-law.
his father-in-law and mother-in-law
Hmm.
of the deceased. Page 26, PW4. I know the accused person standing in the dock of the court today. I know complainant Pinaki Acharya of Koliabor police station. I know this is Jan Bora, who was my nephew. The occurrence took place more than 1 year. It happened during Fakua time. On the relevant day of Fakua, my nephew Jan Bora was missing from his house. Accordingly, we orally informed the Koliabor police station about the fact. After 3 days, I heard from my neighbors that there was a quarrel in between Jan Bora and his father-in-law Krishna Biswas. After 3 days of the occurrence, I along with villagers and police went to the house of Krishna Biswas, but Jan Bora was not found. After 6-7 days, I along with villagers and police went in search of Jan Bora to the bank of Kolong River. We noticed the dead body of Jan Bora on the Kolong River and his wearing apparel shirt was seen nearby the dead body. The dead body was covered with meteka. Thereafter, police immediately brought sniffer dog to the said spot. One rope and one pair of chappal were lying near the dead body. The sniffer dog, having smelled the rope and the chappal, went to the house of Krishna Biswas. We all followed the sniffer dog along with police. Police arrested Krishna Biswas and his wife. Police recovered the dead body, but it was without head. We recognized the headless dead body of Jan Bora from his wearing apparel. Police took the headless dead body of Jan Bora to Koliabor police station. Police took both the accused in custody and took them to the police station. Myself, along with many people, went to the police station. On interrogation, accused Krishna Biswas disclosed in front of us to the police that he beheaded the dead body and kept the head at a little distance from the place where the dead body was found. Because of the jungle in the riverside and darkness of night, the head was not searched at night. In the next morning at about 9:10 a.m., I, along with police and many other people and media persons, went to the side of Kolong River, where previously the dead body of Jan Bora had been found. Accused Krishna Biswas led us to the place where he had concealed the head of deceased Jan Bora. The head was slightly floating and was covered with meteka. He also confessed in front of us that he had severed the head of Jan Bora by cutting with a knife. Accused Krishna Biswas led the police and the villagers and showed the offending knife kept inside his house. Police seized the offending knife as shown by the accused in our presence. Exhibit 6 is the seizure list and Exhibit 6.1 is my signature. Material Exhibit C is the said knife seized by police and I have identified this today. Police recorded my statement during investigation. Cross-examination by defense. The length of the wooden handle of Material Exhibit C may be 4 inches. The height of the iron portion of Material C may be 6 inches. Such type of knife is available at everybody's house. Now this part, Lordship may highly that because there is no FSL, they have not proved the said knife to be the weapon of offense. They have merely recovered that knife and it was not proved. And even in the postmortem report, there is no mention what type of weapon was used.
It's a general statement by somebody. He says that this knife will be available anywhere. I may not have that knife in my house. It's a general statement. It's not a contradiction.
Such type of knife is available at everybody's house. Jan Bora was dealing in broiler farm business. Jan Bora had broiler farm at Gumutha Gaon, Kuaritol. He had day employees also in the farm. The farm was at the backside of his house. My house is at a distance of 200 meters from the house of Jan Bora. He engaged day laborers. I cannot say the name of the laborers engaged in the farm of Jan Bora. On the day of Fakua itself, I knew that Jan Bora was missing. Kuaritol police station is at a distance of about half kilometer from our house. Jan Bora was living with his parents. Still, Jan Bora's parents are alive. Dhan Bora is my nephew. Dhan Bora was also living with Jan Bora. I am HSLC passed. On the relevant night of Fakua, we did not inform police. After 2 days, the father and the wife of Jan Bora lodged written FIR at Kuaritol police station. I did not accompany them. On my own, I did not inform the police. On the relevant day of Fakua, I saw Jan Bora. He was enjoying Fakua along with 4 or 5 friends. After Fakua, I did not see Jan Bora alive. Accused Krishna Biswas was dealing with 10th ward. I saw Krishna Biswas after missing of Jan Bora and he was working at our village. I saw Krishna Biswas on the last occasion in police custody at the time of recovery of the head of Jan Bora. A section of battalion also accompanied the police at the relevant time of recovery of the dead body. He was handcuffed. On the day of recovery of the headless dead body of Jan Bora, accused Krishna Biswas was arrested. So far, my knowledge goes on the basis of the Ezahar lodged by the father and the wife of Jan Bora, police registered a case. When the headless dead body of Jan Bora was spotted, police and villagers were present. Without the search, it would not have been possible to identify the headless dead body. I could recognize the headless dead body of Jan Bora from the mark on his back which I saw since his childhood. There was flesh on the back of the headless dead body of Jan Bora, but on the front side, there was decomposition. As there was foul smell coming out from the dead body, as such, only police, myself, and 6-7 other persons were present. At that time, magistrate was also present. The downside of the dead body was in decomposed state. Police did not ask me. It is not a fact that the shirt found nearby the dead body was not of Jan Bora. It is not a fact that dead body was completely beyond the point of recognition. It is not a fact that the shirt nearby the dead body was placed by police. When the dead body of Jan Bora was searched by police, the shirt was sticking with the dead body. I did not see police taking photograph of the dead body. I did not see police making videography of the occurrence, leading to recovery of the dead body of Jan Bora. After getting the information regarding the trees out of the dead body of Jan Bora, his parents become senseless and hospitalized. The house of Jan Bora is at a distance of 3 kilometers from the place where his dead body was found. On the relevant day of finding the dead body of Jan Bora, we started searching right from 9 a.m. Krishna Biswas was arrested by police from his house after the dead body of Jan Bora was traced out. From the day of Fakua till recovery of the dead body of Jan Bora, Krishna Biswas was at his house. It is not a fact that Krishna Biswas did not show the head of the Jan Bora, nor confess that he has severed the head of Jan Bora from the dead body. Krishna Biswas confessed in the police station. Previously, he did not state anything. At the time of recovery of the head of Jan Bora, Krishna Biswas came to with police and recovered the head. On that day, he along with police and battalion party came. He was handcuffed with one hand. On the next date also, we came to the police station and then to the place where the dead body, where the head was found. I did not accompany police in the police vehicle. It is not a fact that the accused Krishna Biswas did not show and recover the head of Jan Bora, and he also did not confess about the fact. On the day of recovery of the headless dead body, about 200 to 300 people gathered. It is not a fact that sniffer dog was not brought by police to the place of occurrence of the headless dead body of Jan Bora, and sniffer dog also did not go to the house of Krishna Biswas. It is not a fact that the sniffer dog did not smell the rope and chappal and then led us to the house of Krishna Biswas. I stated before police in my statement that I accompanied police at around 9 p.m. on the relevant date of recovery of the headless dead body of Jan Bora. It is not a fact that I am a police informer and I was utilized by police in the investigation of the case. I do not know where Exhibit 6 was prepared. It is not a fact that I know nothing about the occurrence and I have falsely deposed. PW 5, page 31. I know both the accused persons, but I do not know their names. Their house is at a distance of 3-4 kilometers away from our house. I do not know the complainant of this case. I know this is Jan Bora. He was my nephew, son of my elder brother. The occurrence took place around 2 years back from today. After 4-5 days of occurrence, I could come to know that Jan Bora had killed by his parents-in-law. The accused persons are the parents-in-law of Jan Bora. After 4-5 days of occurrence, I, along with other villagers, went to the house of accused persons. Police showed me a knife and seized it in my presence. I can recognize the knife today, which police seized in my presence at the house of the accused person. Material Exhibit C is the said pottery knife, which police seized in the house of the accused persons in my presence. Exhibit 6 is the seizure list, and Exhibit 6(2) is my signature. I do not know how Jan Bora died. Cross-examination by defense. I am driver of a bus of a private school. What I have deposed before this court is based on information. I went to the place of occurrence at around 9:10 a.m. I cannot say the names of the persons who were present with me at the time police obtained my signature in the seizure list. This type of knife is found in everybody's house. Police did not record my statement. Police obtained my signature. I do not know the contents of Exhibit 6 seizure list. Now PW6, page 33. On 23, so this is the evidence of doctor. Lordship will find the opinion part at page 34. In my opinion, death was due to shock and hemorrhage as a result of decapitation, which was anti-mortem in nature. And in cross, your lordship will find cross-examination by defense. The dead body was identified to me by ASI Atul Rava, Anisur Rahman. So on 22/3/2017, the dead body was officially received at Nagaon BP Civil Hospital. And on that day, I was not in postmortem examination duty. Parts of the body and head were not sent for forensic examination. It is not a fact that head received on 23/3/2017 was not of the dead body received on 22/3/2017. There was no family members to identify the dead body at the time of postmortem examination. Except decapitation on the mark, I did not find other injury on the body. So that is what I was placing, that the initial case was that he hit on the head of the deceased, for which he died, and subsequently his head was severed. But that in the other injuries are not found in the body. Except decapitation on the neck, I did not find any other injury on the body. Decapitation means cut of the neck by heavy sharp cutting weapon. But in my postmortem report, I have not specifically mentioned the nature of the weapon. Petrification starts after 72 hours. The process is slow when the body is under water. It is not a fact that dead body on which I conducted postmortem examination was beyond recognition.
Because, Mr. Ahmed,
Lordship.
you see, as per the doctor's evidence, the head and other parts of the body has putrefaction has set in. So therefore, under that circumstances, it will be very difficult to find a head injury.
Probably, but they could have find whether there was fracture or not of the bone. That they can identify. Probably.
No, fracture was not there.
They are
Because
not
fracture could have been ascertained.
Yes, but their case is that initially their head injury was there. Therefore, he died. So that injury might have caused fracture also. Because
May not be. We
without
can't, we
that-
can't say right now.
Lordship,
When there was a putrefaction of the body,
Lordship.
then we can't have the actual status.
Right.
But fracture can be ruled out because there was no fracture.
Lordship,
Because fracture would have been detected.
Lordship. That part, I am only on that part. Because if a person died, there would be a severe head injury also. Because he died on the spot.
Can't say.
Because probable thing, I'm placing the probable thing, because they have not proved it beyond reasonable doubt. Either this way or that way may happen. The entire parts of the body was under putrefaction. It is not a fact that the deceased did not die due to decapitation. Now, page 36, PW7. I know accused Krishna Biswas and Onita Biswas standing in the door. I also know complainant Pinaki Acharya of this case. I also know deceased Jan Bora. He was my friend and co-villager. The occurrence took place more than 1 year back. On the date of Holi in the year 2017, Jan Bora and we played Holi during daytime in our village. He stated to me that in the evening he would visit the house of his parents-in-law at Koliabor, Tiniali. On the next day, Nilakanta Bora, the father of Jan Bora, came to my house and asked me whereabouts of his son Jan Bora. I told him that we were playing Holi during daytime, and Jan Bora told me that he would visit the house of his parents-in-law at Koliabor, Tiniali. Thereafter, he left our house. For 3-4 days, Jan Bora was missing and his mobile phone was found switched off. After 3-4 days, I visited the house of accused Krishna Biswas and Onita Biswas and asked them whereabouts of Jan Bora. Onita Biswas told me that Jan Bora had visited their house and he had gone away after collecting money from them. After 9-10 days from the date of Fakua, we were searching Jan Bora here and there. Dhan Bora, the younger brother of Jan Bora, asked me to search his brother. After 9-10 days from Holi, we found the headless dead body of Jan Bora in Kolong River covered by Meteka on the backside of the house of accused Krishna Biswas. At the time of recovery of the headless dead body of Jan Bora, 2 police personnel were present with me. Dhan Bora identified the headless dead body of Jan Bora as his brother on the basis of his wearing cloth on the dead body. Thereafter, police brought sniffer dog and put the dog nearby the dead body. The sniffer dog ran straightway from nearby the dead body to the house of accused Krishna Biswas. Accordingly, we along the police also followed the sniffer dog. The dog entered into the house of Krishna Biswas. Accordingly, police arrested Krishna Biswas and his wife Onita Biswas. Thereafter, police took them to the police station. We also came to the police station. Police made interrogation to Krishna Biswas in front of us. At first, he denied committing murder of Jan Bora. But subsequently, he disclosed in front of us that he beheaded Jan Bora and had kept the head at a certain distance from his body. By that time, it became night, and as such, police did not go to the place of occurrence. On the next morning, police took Krishna Biswas to the place of occurrence at the bank of Kolong River, and we also accompanied them. Accused Krishna Biswas found out the head of Jan Bora covered under Meteka at a distance of about 10-15 feet from the place where the headless dead body of Jan Bora had been found. On interrogation by the police, Krishna Biswas went to his house, and in our presence, he showed the knife with which he severed the head of Jan Bora. I was present at the time of inquest on the dead body of Jan Bora. Exhibit 8 is the inquest report, and Exhibit 8.1 is my signature. In the evening following recovery of the headless dead body of Jan Bora, Kailash Hazarika made audio video of the statement of accused Krishna Biswas at Koliabor police station. At that time, I was also present at the police station. Police seized the video cassette in my presence. Exhibit 3 is the video cassette, and Exhibit 3.2 is my signature. Material Exhibit A is the said CD seized by the police in my presence. Police recorded my statement on 3 occasions. The time of recovery of the headless dead body and another after recovery of the head. Cross by defense. Prior to the recovery of the headless dead body of Jan Bora, I did not meet police. I have flying businesses. On the day the dead body of Jan Bora was recovered, the OC of Koliabor police station and other police personnel were present, but I do not know their names. I know ASI Pinaki Acharya as witness of Koliabor police station of any case under Koliabor police station. Lordship may kindly note this. I act as witness of Koliabor police station of any case under Koliabor police station. Later on, this witness says that he acts as a witness of those occurrences taken place in his presence. I cannot remember the dates on which police recorded my statement in connection with the present case. Police recorded my statement on the date of recovery of the headless dead body of Jan Bora and also on the next date when his head was recovered. On the next day of Fakua, I came to know about missing of Jan Bora. I myself did not file any Ejahat at Koliabor police station in the matter of missing of Jan Bora, who was my friend. From the next day of Fakua till recovery of the headless Jan Bora, although I came to know about his missing, but I did not know about the details of the occurrence. On the date of recovery of the headless dead body of Jan Bora, police arrested accused Krishna Biswas and his wife Onita Biswas, and they kept in the police lockup on the relevant night. But I cannot say for how long the accused persons were in police lockup. I do not know whether police took both the accused persons before the magistrate for recording their confessional statements. I was at the police station when accused made statement before the police. The statement was made in the evening at the police station. Apart from me, other persons were also present. Myself, Kailash Hazarika, Paran Pachi, Nipen Borua and Dhan Bora were present at that time. It is not a fact that I do not deal in flying businesses and I am a professional witness of police. By the side of Kolong River, where the dead body of Jan Bora was recovered, there is the house of accused, and at a little distance, one broiler farm is situated. At the time of recovery of the headless dead body, Jan Bora, I, along with many other villagers, were present. 2 police persons were also accompanied us. I do not know the names of the said 2 police persons. Lilakanto Bora and Dhan Bora were also present at the time of recovery of the headless dead body of Jan Bora. On that day of recovery of his dead body, police took both the accused persons with handcuffs to the police station. The headless dead body was not decomposed, but it was putrefied. On the next day, the head of Jan Bora was recovered on being shown by accused Krishna Biswas. At that time, I, along with police persons, were present. At the time of recovery of the head of Jan Bora, only one hand of accused Krishna Biswas was tied with handcuff, and he used his other hand. At the time of recovery, the head was beyond recognition. Police did not ask me in details at the relevant time. I did not state before the police in my previous statement that on the day of Fakua, Jan Bora told me that he would visit the house of his father-in-law, as because police did not ask me. I did not state before the police in my previous statement that I met Jan Bora for the last time on the day of Fakua. It is not a fact that in my previous statement, I did not state that the father of Jan Bora visited my house on the next day of Fakua and asked me about his son Jan Bora. I did not state in my previous statement before the police and that after missing of Jan Bora, I went to the house of Krishna Biswas and Onita Biswas told me that Jan Bora had visited their house and he had gone away after taking money from them. I was searching Jan Bora along with other public. The headless dead body of Jan Bora was recovered by police and police persons were present. I did not state before the police in my previous statement that police came with sniffer dog which ran directly to the house of Krishna Biswas from the place where the headless dead body of Jan Bora was recovered. It is not a fact that I am falsely deposing that Krishna Biswas recovered the head of Jan Bora from under Meteka. It is not a fact that accused Krishna Biswas did not confess before police that he had beheaded Jan Bora with a kotari and kept the head under Meteka at a distance from his dead body. It is not a fact that the dead body which was recovered from the Kolong River was not of Jan Bora. It is not a fact that I am falsely deposing. Now, PW8, Circle Inspector, page 41. On 17/3/2017, I was posted at Koliabor Police Station as the officer in charge. On that day, one Juma Bora, wife of Jan Bora, Koliabor, informed me that 13/3/2017, her husband Jan Bora had been missing. Then I made a GD entry by Koliabor PS GD number 316 dated 17/3/2017. Thereafter, I entrusted ASI Pinaki Acharya regarding missing of Jan Bora. Exhibit 1 is the extract copy of the said GDE and Exhibit 1-2 is my signature. On 22/3/2017, ASI Pinaki Acharya lodged a written Azahar at Koliabor Police Station. On receiving the written Azahar, I registered Koliabor PS case number 39/17, dated 23/3/2017, under section 7. I myself took up investigation of the case. Exhibit 2 is the Azahar and Exhibit 2 is my signature.
It is mice. We have some visitors inside.
Some living beings. Living beings. Some living beings or what, some, or
I,
might be the ice. No.
no.
Mice or mice?
I don't want to instill fear on
Yes. In-
some members sitting here.
Otherwise, it's a scary thing. It might be the ice also inside the AC.
No.
Acha. Eh, suffer karo.
Ice, you are right, but there is a spelling error. M is missing.
Someone can come and clean it up or send it away. He left.
They have interest in law.
Not in this surroundings, it's so impossible for them. It's very unlikely that they will visit this kind of place. Because of the
You see,
papers.
when law is there, everybody gets interested. You speak to your colleague advocate Pallab Bhomik. In his house, the monkeys come and read Constitution of India.
Good side.
That's a good sign.
Before lodging the formal Azahar on 22/3/2017 at about 11 AM, I could come to know from Constable Padma Kumar Bora that dead body of Jan Bora was floating on Kolong River near Koliabor, Tiniadi. Having received the information, I immediately proceeded to the place of occurrence. Thereafter, the headless dead body of Jan Bora was recovered from under Meteka in presence of his relatives and other public, but his head was not found. The headless dead body of Jan Bora was identified by his younger brother Dhanmani Bora. The inquest on the dead body was held by Executive Magistrate Sri Rituparna Bora at the place of occurrence in our presence. I also seized one parcel of chappal along with a plastic rope at the place of occurrence. In presence of witnesses, Exhibit 5 is a seizure list and Exhibit 5-2 is my signature. Then the headless dead body of Jan Bora was sent to Nagaon BP Civil Hospital for postmortem examination. On being suspected, accused Anita Biswas and Krishna Biswas were apprehended and brought to the police station for interrogation. I interrogated and recorded their statement under section 161 CRPC. During interrogation, the accused person stated that on the relevant day of Fakua, Jan Bora visited their house and a quarrel took place in between Krishna Biswas and Jan Bora at their house. During quarrel, Krishna Biswas assaulted Jan Bora with lathi and Jan Bora fell down and died on the spot. Thereafter, accused Krishna Biswas dragged the dead body of Jan Bora tied with a plastic rope to the Kolong River. Thereafter, he cut the head of the deceased Jan Bora and threw the dead body on the river. He also threw the head of Jan Bora into the Kolong River. During interrogation, Krishna Biswas stated before me, I tied the dead body of Jan Bora with plastic rope and dragged towards the side of the Kolong River, and I severed his head by cutting with a knife. I had thrown the headless dead body on water and covered with meteka, and I put the severed head by the side of the dead body and covered with meteka. I had also shown the knife with which I cut the head of Jan Bora, and police seized the same in presence of witnesses.
Just a moment. Yes.
Exhibit 10 is the said statement of accused Krishna Biswas made before me under objection from the defense side. So his 161 was exhibited as Exhibit 10. On 23/3/2017 at about 10:20 AM, the severe head of Jan Bora was searched at Kolong River in presence of accused Krishna Biswas, brother of Jan Bora, and other local witnesses, namely Pranjyoti Pasoni and Kailash Bora. The head was recovered on being shown by accused Krishna Biswas in Kolong River, which was floating on river. The head was identified by Dhan Bora, the brother of deceased Jan Bora. The inquest on the head was held by Executive Magistrate Sri Rituparna Borua. Thereafter, the head of the deceased Jan Bora was also sent to Nagaon BP Civil Hospital for postmortem examination. The statements of the witnesses Kailash Hazarika, Pranjyoti Pasoni, and Dhan Bora were recorded. Material Exhibit B is the chappal and rope which I seized from the place of occurrence. Material Exhibit C is the said knife which was used by accused Krishna Biswas to sever the head of Jan Bora, and I have identified the knife today. During the course of investigation, accused Krishna Biswas and Anita Biswas were arrested and produced before the court for their judicial custody. I drew a sketch map of the place of occurrence being the house of accused Krishna Biswas. Exhibit 11 is the said sketch map, and Exhibit 11.1 is my signature. Exhibit 12 is the sketch map of the place of occurrence of Kolong River, where from the headless dead body and severed head was recovered. Exhibit 12 is my signature. After collecting the postmortem report of the deceased Jan Bora, I submitted charge sheet against the accused persons under section 302(201)/34 IPC. Now, cross examination by defense. As per the missing DD, Jan Bora was missing since 13/3/2017. The house of Jan Bora is at a distance of 1.5 kilometers away from Koliabor police station. Apart from missing information, no other written information was received till filing of FIR by ASI Pinaki Acharya. till 22/3/2017. From the date of 17/3/2017 being the date of missing information, no case was registered. As such, there is no mention in the case diary. I took custody of both the accused persons on 22/3/2017 for the purpose of interrogation. On 23/3/2017, they were arrested and forwarded before the learned judicial magistrate at Koliabor on the same day. On the date of recording the statements of the accused persons on 22/3/2017, the dead body of Jan Bora was not recovered. On 23/3/2017 at about 12 noon, the accused persons were formally arrested. After sending the accused persons to judicial custody, they were not sought for further police custody. On 22/3/2017 at about 11 a.m., the headless dead body of Jan Bora was recovered. On 23/3/2017, the severed head was recovered. The challan by which the severed head of the Jan Bora was sent to Nagaon BP Civil Hospital is not found in the case diary. Exhibit 10 statement. Exhibit 10 statement, the accused Krishna Biswas did not state before me that he would show the severed head of Jan Bora. So this part. After recording the statement Exhibit 10 of accused Krishna Biswas, he was kept at Koliabor police station under the guard of police. It is not a fact that on 23/3/2017, before we proceeded to the place of occurrence for recovery of the head of Jan Bora, public were already present there. I took Krishna Biswas to the Kolong River and he also accompanied me. It is not a fact that on the intervening night of 22/3/2017 and 23/3/2017, accused Krishna Biswas was severely tortured by me and I influenced him to help police to recover the head of Jan Bora. It is not a fact that police had already recovered the head of Jan Bora before we reached the spot. It is not a fact that at the time of recovery of the head, a large number of public were present. After recording Exhibit 10 statement of accused Krishna Biswas, his further statement was not recorded. It is not a fact that I forcibly took accused Krishna Biswas to Kolong River under handcuff. When I recorded Exhibit 10 statement of accused Krishna Biswas, I did not record that he would show the severed head of Jan Bora. On 23/3/2017, before recovery of the severed head of Jan Bora, on that day, I did not record his statement. On the intervening night of 22/3/2017 and 23/3/2017, no public was present when the accused stated that he would be able to show the severed head of Jan Bora. It is not a fact that accused Krishna Biswas neither made an Exhibit 10 statement nor he led me to the place of occurrence and recovered the severed head of Jan Bora. It is not a fact that at the time of recovery of the headless dead body of Jan Bora, it was beyond recognition. It is not a fact that the severed head which was recovered was not of Jan Bora. I did not find any blood stain on material Exhibit 3 for which it was not sent for serology test. The statements of the accused persons were made video recording at the police station. PW3 Dhan Bora in his previous statement did not state before me that while he visited the house of the accused persons on the next day of missing of Jan Bora, accused Anita Biswas stated to him that Jan Bora had come to their house to collect money. PW3 in his previous statement did not state before me that neighboring people disclosed him that there was a noisy situation in the house of the accused persons on the previous night. Nitumoni Bora in his previous statement before me did not state that on the next day of Fakua, the father of Jan Bora visited his house and asked him about Jan Bora. It is not a fact that the accused persons are innocent and they were arrested on mere suspicion. So this is the prosecution evidence. And therefore your lordship will find the statement recorded under section 313 of the accused person. 49 is the is of appellant. What do you have to say about allegation in exhibit 2 FIR lodged by Pinaki etc.? The allegation made in the FIR against me are totally false. PW1 has given evidence to the effect that you committed murder of victim Jan Bora by assaulting on his head with a bunch of tree in the courtyard of your house in between 13/3/2017 and 14/3/2017. What do you have to say in reply? False evidence. I do not know how Jan Bora died. Jan Bora had come to our house prior to 20 days of his missing. Further deposed that after committing murder, Jan Bora, you along with wife Onita Vishwas dragged the dead body and had thrown on the river. Thereafter, you covered the dead body with meteka. What you have to? False evidence. Brother of Jan Bora supplied the rope used for tying the cattle to the police. Koilas deposed that after 10 days of the occurrence, dead body of Jan Bora was recovered in the Kolong River on the backside of your house. And on the next day, on being laid and shown by you, severed head of Jan Bora was recovered in the Kolong River. False evidence. Police on the previous date recovered the headless body of Jan Bora from Kolong River. Police brought me to the Kolong River and forced me to show the head. Then I stated that since I was not involved in the occurrence, as such, I did not know anything. On the next day, police brought me and the family members of Jan Bora, and police found the severed head of Jan Bora floating in the certain distance from the place where his dead body had been recovered on the previous day. PW3 Dhanbora had also testified that after 7-8 days of missing of his elder brother, so I'm just skipping this, at least he has given some explanation in his 313 lordship. And if your lordship see that regarding the recovery of knife, that probably is not here. Seven days of missing. And question number 8. It is there. Question 9. It is about that exhibit 10. Now, page 93, Lordship may kindly see.
Page
93. Exhibit 8. This is the inquest report. This is regarding the body, but there is no mention about head. And police also did not made any separate inquest report for the head.
But the circle inspector says that there was a separate inquest report for the
But
head.
it is not exhibited. But in the paper book, it is only that inquest report. Exactly. . Because because there is dispute regarding when it was recovered.
Pardon me?
There is dispute when the head was recovered. Because some witnesses say that it was recovered on the same day at 3 p.m.
At 3 p.m.
and others say on the next day on being laid by accused,
That is only PW1.
PW1. And
Others, all the rest of them are saying next day.
but here my submission would be, Lordship, that PW1 is not declared hostile. And unless he is declared hostile, prosecution is bound by his evidence.
But the inquest of the head is there, perhaps not exhibited. Inquest of the head is there by the circle officer,
But not exhibited.
not exhibited, not marked. Otherwise, it's in the exhibit file only. I don't see any markings here.
You have good, you have a good circle inspector.
These investigations, had these investigations been
The
good?
investigation is outside, but he intends to keep people out from the jail.
Mm.
Intentions are good,
Mhm.
very honorable intention.
Yes.
But Ms. Jan,
Was conducted
entire-
yesterday.
the
And
entire prosecution has failed. It will lead to privacy. We have not heard you.
Hmm,
Privacy, what Mr. Ahmed is submitting
hmm.
is a case of acquittal because the appellant, he was in police custody when that alleged confession is made.
Yeah, those statements will not be relevant.
Will not be relevant. So because if
Other
that statement,
circumstances,
because if that statement goes,
Hmm.
then other circumstances has to be proved.
Hmm.
And chain of circumstances is not complete.
chain, I just will try to somehow bring the
No,
chain.
it's okay. I have not heard you.
Yes.
Privacy with what Mr.
Ah.
Ahmed is submitting. His presentation.
Hmm.
What his presentation was worth, he will show us.
Whatever is there on the records, I'll show that. If he has finished, or he has not finished.
Hmm.
Otherwise, this, and this inquest shows that the inquest was done yesterday. So inquest report was of 23rd. And the head, the inquest of the decapitated body, the body was
Body
conducted
was
yesterday.
previous day. Second
White
day when the head
report.
was recovered, then the second
Huh.
inquest by the same
Same person,
magistrate.
Pollopora. No, Pollopora? Yes, Pollopora. Same magistrate. Is suspected to be of the same person, the head. The head is shivered from by a sharp object.
But that is not executed.
Hmm.
And now, Lordship, may I go to page 73, the findings of the learned trial court.
Just take a break and come back.
Lordship.
We'll take a break. We'll take a break and come back.
Kima? Oh, ada benches sana. Lagi mo ito. Oh, saan ko kulo lagi? Tahu ni. সঁচাকে নিগনি চিকা কিবা আছিলে নেকি? চোৱাচোন চোৱা আছে চাগে। আহা। হেৰি কাঠৰ ভিতৰত। খুলি চোৱাচোন। খুলিব নোৱাৰি। তলা
After discussing the evidence, it is said that paragraph 26, the above discussion and analysis of evidence have established the following circumstantial evidence.
Yes.
Paragraph 26, the above discussion and analysis of evidence have established the following circumstantial evidence. Number one, this is Jan Bora, who is the son-in-law of the accused person, visited their house in the evening on 13/3/2017, being the date of his missing. Number two, the headless dead body of Jan Bora was recovered from Kolong River on the backside of the house of the accused persons. On the basis of the information, so here your lordship will find that he late, that is not accepted by the trial court. On the basis of the information made by the Krishna officer during custody of PWA and on being shown by him, the dissected head of Jan Bora was recovered, which was kept concealed under water hyacinth on Kolong River on 23/3/2017. Now here there is discrepancies, and PW1, who was initially recovered the body, and thereafter he said, lordship, at 3 p.m. the head was recovered, and he is not declared hostile. Unless he is declared hostile, his evidence prosecution is bound by his evidence, lordship. And if his evidence remains, then there is doubt whether it is recovered prior to the arrest of the accused or after arrest. So that circumstance is not conclusively proved. The death of deceased Jan Bora was caused by decapitation, and material exhibit C night
No, you
was.
see, there is another way of looking at it. Number one, if there is a dead body, so the dead body is available and it was found in decapitated state. The head was not there. Now you see, once by any means, either circumstantial or direct evidence or whatever, it can be found that it can be held that the man was murdered. Obviously, when the head is severed, well, it has to be murder because one cannot inflict that to himself. So therefore, the finding of the head of the dead body is not material then, because the incident has been proved. So whether the head of the dead body is recovered today or tomorrow, or the day before, doesn't make much of a.
Probably in other case it will not be material, but in present case it will be material because, lordship, they are relying on circumstantial evidence, and they wanted to show that dead body was kept hidden by the appellant, and therefore he led the police party to recovery of the head. They wanted to project that, except that there is nothing on record, lordship. Because if that part goes, there nothing remains for prosecution to convict me.
Okay.
Number 4, the death of Jan Bora was caused by decapitation, and material exhibit C night recovered from the house of accused Krishna Biswas on being shown by him. Here also this circumstance is not conclusively proved, lordship, because the weapon which was recovered from the house of the appellant is not proved to be the weapon of offense. It may be a weapon from which is recovered on being laid by accused. I'm not disputing that at this stage. But whether this weapon was used in the crime, that part is not there. Mere recovery will not do, because already I have pointed out before Lordship that the knife which was recovered, they admitted that in every household it generally remains. Unless and until they show that this weapon was used in the crime, mere recovery will not made an offense. Lordship. So these are the circumstances, and on the basis of this, the appellant is convicted. And now I'm relying on three judgments, Lordship.
No, this should happen only if we accept your statement that the leading to recovery was not proved.
Yes.
Because if leading to recovery is proved, then if I ask the accused person to bring the weapon of offense, he brings that knife.
Lordship.
So that would be a conclusive proof that that is the weapon of offense. Because it's 20 days after.
Lordship.
So
No,
the
but-
bloodstain may not be available.
No, but in that case, Lordship will go kindly see the evidence of doctor. He said decapitation, and decapitation means with heavy weapon if it is decapitation. Then I'm just again taking your Lordship to that part. Evidence of PW6, page 33. And relevant portion your Lordship will be on page 34.
No, can we rule out from Kotari
Lordship.
that a head cannot be severed? Can it be ruled out?
No, it cannot be ruled out, but there is just I'm reading one line, Lordship. Decapitation means cut off the neck by heavy sharp cutting weapon. And here, Kotari is not a heavy sharp. I'm just placing to your Lordship that from the evidence, two views are possible.
Which is that page?
Page 34. Last paragraph, third line.
Prostitution. That's it. Dictionary is open. Dictionary. Decapitation, that not cutting of the head. Example of a woman, it is head. Cutting of the head. Your heavy weapon is not there. So this is something doctor has added. First, it is his evidence. It has been not impeached. Those are the words added by the doctor. Decapitation, as per the dictionary, does not mean heavy weapon.
Probably it is in medical term, but they have their witness saying, so it is not my witness.
No, I understand, but this is not there in the dictionary.
Right.
Therefore, we'll have to presume that the doctor added words.
No, but again, I will submit that if prosecution witness is not declared hostile, his evidence is binding. That judgment I will place into a loss of another apex court. Because it is their expert. They are experts saying this. The report who has prepared this, he has said.
No, he is not an expert. He did not come to the witness box as expert and within the meaning of 45 of the Evidence Act.
That,
He's a doctor conducting postmortem. So therefore, part which is his explanation, that may not be considered. It's not the falsis in no falsis only is not applicable here. So therefore, that part which is his opinion can be discarded by the court.
My only submission to your lordship is that his evidence that evidence of PW 1 and 6, they are not declared hostile. And when they are not declared hostile, it is binding on prosecution. And if this evidence remains, two views are possible. First, that head was recovered.
No, let us see. Let us test this. Let us test this. Now, a witness comes A. He says that this High Court building was constructed by him. This land was originally his, and he had constructed this High Court building. He brings 10 more witnesses, all say the same thing. It is the ancestral land of this man, and this High Court building was constructed by him. Now, there are 10 witnesses to that to the testimony, and they have not been cross-examined. Now, what happens to the ownership of the High Court building?
That probably also here because they are trying to project a case lordship, in the present case. They are
No, so
trying to-
therefore, you see, it's not all evidence of the witness which is acceptable to the court. So there are circumstances where the court may save the evidence and accept what could be the best evidence, and others can be discarded.
But at that lordship, but if in the regarding same fact, two evidence are there, lordship.
But then you get the
Then one
benefit.
cannot be discarded because.
Then you
lordship,
get the
other is-
benefit.
other is there.
Then you get the benefit.
That only I am only on that part. Because they are witnesses saying that decapitation means that neck means cut off the neck by heavy cutting by heavy sharp weapon. And they have recovered a knife, that is
Kotari.
pottery. So that injury which the dead body was found may not be caused by that knife. That probability is there because the entire case is based on circumstantial evidence. And when the case is based on circumstantial evidence, they have to prove each and every circumstance beyond reasonable doubt. That probable, that word is there.
Yes.
Just I'm summing up my argument. Also, here my case is that the circumstances which are relied on by the prosecution side are not conclusively proved beyond reasonable doubt. And therefore, the benefit would go to the accused. Lordship. That first, Lordship, I am relying on a judgment of Honorable Apex Court in
The
AR.
description of Qatari is there. The,
2 feet long. Length about 2 feet with wooden handle. 2 feet will be quite long. 2 feet.
No,
2
2
feet
feet, right?
4 inch, 4 to 6
Of
inch.
course, the original records that I'm holding, the page is little torn.
huh,
Otherwise, what I can read is 2 feet.
No, 6 inch as per PW1. Page
No, that is
11,
handle.
sir.
that is handle,
No,
That is
the size
wooden
of the
handle.
size of the knife was 6 inch in length.
No, Caesar list concern, Caesar, Caesar,
There will be in the scissor list.
Caesar list concern.
Scissor list, MR is starts from 79 onwards.
Lordship.
Here one. 2 feet. About 2 feet. The feet spelling is wrong with wooden handle.
Original.
Originally it is wrong. 2 feet. This is little torn, but I can somehow make it out. Yes, sir. 2 feet to spelling to good. Man, bad. Yes, more years ago. 2 feet. It should be double E. FIT it is. About 2 feet and written N. Written N to people. As N.
And
2 feet with
2
wooden
feet.
handle
Spelling is wrong
written
even
as
in,
N.
even in original it is FIT, but it should be FWT. 2 feet.
but that probably your lordship will can see that evidence of PW1, then evidence of PW4, all says 6 inch.
Exhibit 6, I think, is proved by PW4.
Mm.
Yes. And he says it is about 6 inch. At page 27, cross examination, second line.
Page 28,
Page 27.
27.
Yes, cross examination, that first, second line, your lordship will write.
The height of the iron portion of materials exhibit C may be 6 inches.
Perhaps 2 feet is inclusive of the handle. Can
No,
be-
no,
No.
here it's very clear. The height of the iron portion
Mm.
of material exhibit C may be 6 inches.
And-
Maybe
and-
he
and-
is
and-
just an
and tell
ocular
4 inch.
witness.
No, 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 but he's a Caesar witness.
These are witness.
He is PW.
Four.
PW4,
Yeah,
page
Four.
27.
He is a Caesar witness. কি নাম আছে এটা?
And we have identified that in the code. Last 2 lines of his examination in chief, page 27.
Page 27, last
Yes.
3 lines.
Yes.
Police seized the offending knife as shown by the accused in our presence. Exhibit 6 is the Caesar list. 6-1 is my signature. Material exhibit C is the said knife seized by the police and I have identified it today.
Crossover board.
Oh, it's just cross-out.
Page 27 of the paper book.
Paper book, I don't have. I'm seeing the original.
Huh.
Yes, yes, seized the origin. Is a Caesar list. He is what? Joykanta Bora.
Huh.
Joykanta Bora's name is not. Oh, it's there.
Ah, yes.
Sri Joykanta Bora.
Now you see these 3 lines, I am reading it again.
Uh-huh.
Exhibit C is the Caesar list.
Mm.
6-1 is my signature. Material exhibit C is the said knife seized by the police and I have identified this today.
Mm.
So it's not that he does not know. He takes responsibility of identifying that.
But then the fact remains, the Caesar list shows that the length of the
So
Kotari
that has
is.
been demolished in cross examination. You see,
Hmm.
witness says scissor list. Then he gives the size of the metal.
Yes,
So 2 feet falls apart.
of course, ocular evidence is the actual substantive evidence here.
Huh.
But
And PW5, he is also Caesar witness.
Hmm?
He says Kotari. Page 31, he is also Caesar witness.
But he is not asked.
He's Caesar witness, Gozen Bora.
No, he is not asked about the.
The size he is not saying, but he used the word Kotari.
doesn't do you have to open?
Gozen Bora. PW5.
He might be near. Amal Bhuya is not examined, no?
And he says that this type of house, this type of
No.
knives is found in everybody's house. 2 feet knife, at least, maybe in my house you will not get it.
That will be a kind of machete. But the fact is, he was already injured when he had cut his head. This is what the evidence is. Doctor had said no injuries, but then it's a decomposed body. He was already injured.
Not
Thereafter, he had cut him. So possibility that with that knife, the neck,
If it is 6 feet, 6 inches, then you can't cut it. Because you have to sever the neck bone.
it's a decapitated, it's shivered.
Huh?
It is shivered, so an injured person shivering his head.
No, but still you have to cut the bone.
And he was, one of the witness said that he was unconscious. I think the accused himself said he was unconscious. He was unconscious. This is perhaps lordship is not, mic is not.
No, I am hearing you.
Acha, acha. This, he was unconscious, the deceased, when he had cut the neck.
He had died.
Uh,
The projection is that he was hit with a branch
branch.
of the tree. Then second version is that he hit with a stick in the head and he died instantaneously.
So that part, whether he died, lordship cannot be so sure, I think.
It is there.
It is a PW1 and in the
He
FIR
died.
also.
One,
Page 4, last line. Last 2 lines. FIR last.
no, FIR, yes. Now PW1, what is it?
PW1 also says same thing.
No, even if he is dead or unconscious, cutting a neck of an unconscious or a dead person with a knife, he said it is 6 inches. He will not be that correct.
But then the evidence goes.
Material exhibit, he had seen the material exhibit.
He has identified it. He says I have identified it. Because you come to this, you see, come to page 11. This is deposition of PW1.
Huh.
You got it?
Hmm.
PW1.
Yes.
Come to the cross examination. Last line, second, 2 last lines.
So it's
At
6
the time I was
inches.
present, I had not seen the Civ 9 code today. The size of the knife was 6 inches in length.
Length,
So it's a confirmation of the size of the knife.
6 inches in length.
So 2 witnesses put it at 6 inches.
Before that, I have not seen the seized knife before this court today. Of course, he was there when he is Pinnacle, he is the complainant. But he had not seen the knife in the court that day, and he is not a Caesar witness. But he is the complainant. He is the one. He was there when it was recovered. I think he is the police officer there,
He's the police officer there.
Pinaki,
Huh.
Pinaki Acharya.
Huh.
Seized by Rajan Bora inspector. But it was seized by Rajan Bora,
Hmm.
inspector, the OC of Koliabor police station.
Exhibit.
Exhibit 6. But perhaps this Pinaki was there.
And page 11.
You see, the date of the FIR is
23.
23,
Sorry, Lord, 22,
22
22 at about 8:30 p.m.
at about 8:30 p.m. Now the seizure is at what time?
No, information received 23/3, 8:30 PM. FIR is 23/3.
20,
23:03.
I can see the format
oh
here.
yes, I'm sorry.
23/3.
23.
And yes, Lordship was saying something.
No,
Time of seizure is not
you see,
Huh.
I'm just looking at page 85 of the paper. There's a seizure list.
Huh.
Seizure list says the date of time of seizure is 22/3/17
At nothing PM.
at nothing p.m.
Huh.
Qatari is 2 feet with wooden handle.
Hmm.
But then the FIR is lost by PW1 subsequently.
Hmm.
And
Yes,
therefore
yes,
his
no,
evidence that the knife was 6 inches.
Hmm.
He would be knowing it.
Huh.
And PS case number is also mentioned in the seizure list.
Huh?
PS case number is mentioned also. Only about PS case number so and so. But
Hmm.
that was registered on the next day. Case was numbered on 23rd. They
No,
say reference
This is
number-
this is not at fault if even if they write it, because the reference is Poliabar PS GD entry of 22/3.
Thereafter, that was put subsequently.
So if
No,
Because that was in the top of
the
the-
original, the seizure
is-
list I'm seeing, okay?
Huh.
That reference Poliabar PS case number is there.
Hmm. At
yes,
the
it is
top.
there.
There.
Thereafter, it is GD entry. It was done, look at the way it is written. So this was later on put. This was in pursuance to the GD entry.
But saying whether I'm not.
You see, these things happen in the police station.
Hmm.
Entries are immediately not made,
Yes.
but the reference is made to the police station. So that the entry of the police case number would not vitiate the
But here the
Seizure itself.
seizure memo was not prepared on the spot. That I'm having one judgment where it is said that it has to be prepared in the spot. If it is prepared in the police station, then it is doubtful. If it is prepared in the police station, then it is doubtful. When it is recovered, they have to prepare it on the spot itself.
okay.
Just, I'm relying on Lordship AR 2011. Mustaqim versus Sirajuddin. Area Sirajuddin versus State of Rajasthan. AR 2011 2769. Paragraph 25 to 29. Okay. Paragraph 24 5, that your lordship is already aware that about circumstantial evidence. It is
Para?
too well, para 25. It is too well settled in law that where the case rests squarely on circumstantial evidence, the inference of guilt can be justified only when all the incriminating facts and circumstances are found to be incompatible with the innocence of the accused or the guilt of any other person. No doubt, it is true that conviction can be based solely on circumstantial evidence, but it should be decided on the touchstone of law relating to circumstantial evidence, which has been well settled by law by this court. That 5 golden principle of Sharad Birdichan is there.
Sharad Birdichan.
Yes. The circumstances from which the conclusion of guilt is to be drawn must or should be, and not merely may be fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused That is to say, they should not be explainable on any other hypothesis except the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should they should exclude every possible hypothesis except the one to be proved. And there must be a chain of evidence to so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. Now, paragraph 27, Lordship. This is what I was placing that regarding that.
I was just
recovery of
imagining
knife.
if I read this para 28. You see, I'm just thinking aloud. Now, suddenly, you while standing here, you have shouted that somebody has pickpocketed your purse. And Mr. Prasad sitting behind, he immediately catches this man with your purse in his hand. And now your friend here, I don't know his name, he will call the police. Latasil police station people are now coming into the courtroom because a crime has happened. Your purse has been pickpocketed. Mr. Prasad has caught this man with your purse. Now the police coming here, what will they carry? They will also carry their what you call this. They are all the formats, the seizure memos, and then prepare that seizure memo here. So I'm just imagining, because otherwise what would happen is that there is a crime going on. I am the presiding officer of the court. My brother and I, we have objection if the police disturbs the court proceedings, and we tell him to just go out and do whatever they want at the police station. You have caught this man, go and do it. And the police goes and takes the this seizure memo in the police station. Now, will it be so bad so as to discard the evidence at all?
In some circumstances, it appears that is required. Because the present case, if actually that the knife was recovered on being led by him, they could have prepared it there itself in the presence of independent witnesses. And regarding that knife, whether it is the weapon of offense or not, regarding that, Lordship may kindly say paragraph 27 of the judgment. With regard to section 27 of the Act, what is important is discovery of the material object at the disclosure of the accused. But such disclosure alone would not automatically lead to the conclusion that the offense was also committed by the accused. In fact, thereafter, burden lies on the prosecution to establish a close link between discovery of the material object and its use in the commission of the offense. What is admissible under section 27 of the Act is the information leading to discovery and not any opinion formed on it by the prosecution. So they have to prove it that this weapon was used in the crime. They at best they could have done through the doctor's opinion that through a knife this can be done. Then
That
probably,
suggestion is not there.
Lordship. And then I'm relying on 2019-17 SCC. That's paragraph 26.
This is Yes,
Paragraph 26. The discovery is a weak kind of evidence and cannot be wholly relied upon and conviction in such a serious matter cannot be based upon the discovery. Once the discovery fails, there would be literally nothing which would support the prosecution case. We have already held that the prosecution, so other part I'm not on that. Only thing that the discovery is a weak kind of evidence. And then your lordship may kindly give that 17(7) SCC.
no,
Which
just
is,
now. This 2009, which was the paragraph?
Paragraph 26.
23,
26.
6.
6.
Please come to this, in this decision, come to para 30. Here there were two accused in this case. The house belonged to Mani. And Mani and Moyaswamy are two accused persons. Now, the case of the prosecution was that the dead body was lying in the room and the door was locked, and from below blood was oozing out. Correct? Now, para 30. We are also not impressed by the evidence of PW1 Arunachalam, who had found the corpse night and realized that something unusual had happened, did not bother to go to next day to reporting the matter. We cannot ignore the evidence of PW5 Chinnamal, in whose field the body was found. So status is also different.
But otherwise also the fact is that other judgments are also there, which
No.
says discovery is a weak kind of evidence. It is only an, it can be used as a chain of circumstances.
No, it's
Chain
okay,
is-
but in this case, the facts are totally different because the dead body was found in apparently at two different places, and therefore it says that you will have to prove it.
No, sir.
The High Court had already acquitted the other accused. The second accused, Mani, in his whose house the dead body was found, he is now being acquitted by the Supreme Court. Yes,
And the third judgment, your lordship will find Anjan Kumar Sharma versus State of Assam, 2017, 14 SCC 359. Here also that circumstantial evidence point is there. I'm not going into that. Already I have submitted one judgment. So I'm just taking your lordship to paragraph 16 and 17.
yes.
It is no more res integra that suspicion cannot take the place of legal proof for something. Unconsciously, it may happen to be a short step between moral certainty and the legal proof. At times, it can be a case of maybe true, but there is a long mental distance between may be true and must be true, and the same divides conjectures from such conclusions. Paragraph 17. It is a settled law that inferences drawn by the court have to be on the basis of established facts and not on conjectures. Relied on Sujit Biswas versus State of Assam. This is my case. The knife which was used allegedly recovered, that is not proved to be the weapon of offense, so that cannot be taken into consideration. And other thing that whether the dead body was recovered, the head of the body was recovered from being laid by the present appellant or not, that is doubtful. PW1 says it is recovered on the same day, and the other witnesses say on the next day. So if two views are possible, and then the view which is favorable to the accused, that may be accepted. Problem.
Yes.
No, before I start with the circumstances, I would like to place the PM report where it is said that what decapitation is antemortem. What I feel is he did not die before he was cut, because Lordship will see the PM report. It is said decapitation, in his opinion, of course, is antemortem, and the scalp was putrefied. Scalp was also putrefied. So, of course, the time of death and all is not shown, not described. Because why I wanted to see the time of death is the body was recovered much after the missing of the person. So, and it was all decomposed to such an extent that even the heart, lungs, everything, vessels, all putrefied. And left lung is all Lordship will say right lung, both lungs putrefied, everything. So what the evidence says is that after 9-10 days, he was the body was recovered. So there is a possibility that these are the people, because someone else coming in between and doing the act, seeing the postmortem report is little unlikely. Of course, Lordship, I'll go to the circumstances now one by one. First circumstance, of course, Lordship has already gone through the case. The first circumstance would be that he had gone to his place on 13th. Deceased has gone to the place of the accused on 13th. This is a settled, there is no dispute with that fact. That has been stated by PW3. Lordship, I'll just point out those sentences where they had said, PW3, he had said, Lordship may not go through, I'll just read it out. PW3, he had said.
All of them have said that he wanted to go there, but nobody saw him going there.
Nobody saw, but sister-in-law, the wife said that he went there. PW3, he said that my sister-in-law, because he is the brother of the deceased, when I asked Anita, this one, Lordship will see this PW3, the brother of the deceased, my elder brother was missing. I was searching after inquiry. We came to know that my elder brother Jan Bora had come to the house of his father-in-law, Krishna Biswas, in between 7 PM and 9 PM on 13/3. The next day was Tuesday. On that day in the morning, myself and my two friends, this is another circumstance. Because here he said, in between 7 to 9 on 17th, deceased went to the place of the accused. Another place I've also got that sister had told him that he had gone. Then this fact was also stated by PW7 that he had gone. Lordship will see the PW7. PW7 is the co-villager, a friend of the deceased. He stated to me, few lines from the top, we were playing Holi. He stated to me that in the evening he would visit the house of his parents-in-law in Koliabor. there seems to be a contradiction as far as 7 is concerned. But just see,
You're in.
But con-
7.
PW7, but the contradiction is not proved as is required. PW7, Lordship will see the first 4 lines from the top. On the date of Holi in the year 2017, Jan Bora and we played Holi during daytime in our village. He stated to me that in the evening he would visit the house of his parents-in-law at Koliabor, Tiniali. But the fact remains he went there to the house of the accused. Nee, sister-in-law probably কলে যে এটু করেছে Then the second Lodge. Sister-in-law probably কলে এখানে কেউ কোয়া নাই হা কি question put করা নাই
The circumstance which is not put in P13 better to rely on.
আচ্ছা এটা reply দি দিবি বাৰু whether that has prejudice নাজানো এইটোৱে হ'ব আৰু নহয় আৰু 3টা পিছতো উঠিব হা এই আছে পাঠাত দেখা নাই জানো কি কৰে নাই নাই মিছা মন নাই নিদিয়ে নিদিয়ে May please, Your Lordship.
Yes,
The first circumstance that I've already said that the accused when the deceased went to the house of the accused on 13-3, as is established by PW 3 and 7. Second is that quarrel had taken place on that night itself. That is stated by PW 3 and 4. Lordship will go to the PW. Second one is that there was a quarrel.
No, the first, on the first thing, you have to explain to us,
Not
because what we understand is a theory that somebody was informed that the person would go there, correct? You get an information that X would be going somewhere, that is okay. But does it fit into the last scene theory? Because it's only a probability when you say that I will go there, whether I have reached there or not, it's that's because presumption is even the normal in a civil parlance, we say that presumption is that one has posted a letter, but
Yes.
receipt is not proved. So therefore, there is a deemed presumption that it is it has been served by section 27 of the General Causes Act.
by examining postmaster and all, we can presume.
No, even if anything is not there, the court to take presumption of service will invoke section 27, by saying that we are presuming it to be served, but rebuttable evidence, if it comes, then we set aside the ex parte and we hear it. So therefore, in a criminal
Yes, yes. The
pro-
hearing is
prosecution.
beyond reasonable doubt, more.
more,
In fact, yes, the Lordship is correct in saying nobody has said that I have seen him going to his place.
Huh.
But coupled with other evidence, 2 and 3, there was a quarrel, and mother, father, the accused have also replied to the villagers that he had come on that night. So coupled with these evidences, Lordship can conclude that yes, he had gone. Lordship will see the second one, there was a quarrel on that night between the accused and the deceased. PW4, Lordship will see few lines from the top. When I asked Anita,
yes,
Page
6 lines from the top,
PW4.
PW3.
P.
PW3, actually, I'm not holding the paper book. I don't have, I'm seeing
Ah.
from page number 16. 6 lines from the top. When I asked accused Anita, did your lordships get it? When I asked Anita Viswas, the mother-in-law of brother Jan Bora, she replied that he had visited their house on the previous date. And after collecting money from her, he had left. Lordship got it. So this shows that he had gone on that day, that night. That is on 13th.
He's the brother of the deceased.
He is the brother of the deceased. He went and asked Anita. Anita is the co-accused who was acquitted. Anita Biswas, mother-in-law, she replied that he had visited their house on the previous date. And after collecting money from her, he had left. There is another evidence. PW7 also said. Apart from that, Lordship will go to PW7. PW7 had also clarified this point. PW7, Lordship will find that page 36. Page number 36, Lordship can skip to
No, just a moment.
Lordship, yes.
He would visit
Lordship,
after only he'll visit. He would visit.
PW3, Lordship is referring to
No. PW7.
7, yes. 7, Lordship will see, yes. I visited the house of Krishna Biswas and Anita Biswas. 10 lines from the top. I visited the house of accused Krishna and Anita and asked them about the whereabouts of Jan Bora. Anita Biswas told me that Jan Bora had visited their house and he had gone away after collecting money from them. So he had gone on 13th.
Please give me that LCR.
Lordship. I'm referring to this LC.
Ah,
Lordship can take it.
No, it's okay.
No. I'm having his paper.
No, just I'll just take 2 minutes. I wanted to look at something.
Lordship.
No, you see, this is the. This is the hospital.
No, it was circumstance.
What is the name of PW3?
Lordship.
What is the name of PW3?
3 Dhanbora. Dhanbora.
Dhanbora.
Lordship.
This page 21,
Lordship. 21.
yes, cross. P
Ah.
of.
Acha, the
PW3.
contradiction.
Yes.
It is not a fact that in my previous statement before the police, I did not state.
No, third.
No. I went to the house of Acha. There is a contradiction.
In between.
Yes. It is not a fact that in my previous statement before the IO, I did not state that on the next day of missing, when I went to house of accused person, Anita Viswas said me that had collected. Acha, there is a contradiction. Perhaps it is also proved.
And then.
PW8.
And then next para.
Huh.
Fourth line.
I visited the house of the accused person in between the next day.
No. In between the next day.
Huh. In between the next day of missing of my brother, Janbora, and recovery of his dead body, I did not go to their house, although I searched him nearby the jungle. In between the next day he went and inquired, but after that he did not go.
No, just read it. That is what I pointed it out.
Yes.
What do you say?
This is what will be there.
Just tell us the real purport and meaning of this.
Because he's
Not just don't read it just in your favor.
Ha ha ha. No, no, not in my favor. I'm not, whatever is there.
In
Because
between the next day of the missing of my brother, what does it mean?
in between the next day of missing of my brother, that means from 14th to 22nd, he did not go.
That means 14, he went.
Ha,
He
four-
said in his chief, he next day he went.
14th he went.
14 is next day.
After 14th, in between the next day, in between the next day and the recovery of the body, he did not go. Matlab, after 14th,
What do you mean by that? Is it 15 or 14?
it has to be 14th.
But he said he went on next day.
He went on next day, 14th. Timing is not given. Perhaps 14th after visiting, he did not go any further.
But look at
But
this,
then yes, there is a Lordship,
look at this is what I wanted,
Lordship. The case diary.
case diary.
Lordship could read it. I couldn't read the notes. I mean the
No, the statement of PW3,
Acha Dhanbara.
Dhanbara. Mr. Das will be able to read it.
No, perhaps the handwriting I can
Handwriting is
somehow.
very nice.
No, that's
Normally we
why.
don't come across such good handwriting.
It,
More naam Sri Dhanbara.
Hmm.
Village so-and-so, Ranga so-and-so.
Miss-
Jila
Mr. Das, I don't need the entire thing. Only that part where he said that he asked Anita Biswas, and she said that he came last night, took money and went away. That only that part, I think that is not there.
Asa naki side of it. On the meter day.
কৃষ্ণ বিশ্বাস আৰু অমিতা বিশ্বাসে মোৰ দাদাক তেওঁলোকৰ ঘৰত কাঠৰ লাঠিৰে মাৰপিট কৰি হত্যা কৰাৰ কথা স্বীকাৰ কৰে।
That is not relevant. Police or Mukambali.
যেতিয়ালৈকে ইনভেষ্টিগেশ্যন কৰি কৰিছিল আমাৰ সন্মুখতে পুলিচৰ আগত কৃষ্ণ বিশ্বাসে কি কৰে কৃষ্ণ বিশ্বাসে কি নাম জলে নাম
75 জন লাগে।
হত্যা কৰি নি কদম নদী
এইটো নাই ন?
তেওঁলোকৰ
সেইটো নাই ন? অনিতা বিশ্বাসৰ ঘৰত যায়
যে পইচাৰ কথা
নাই।
মোৰ দাদা জন বৰা নেকি তাৰ নাম?
Into something. It's not there. That part,
Regarding money part,
that meeting Anita Biswas is not there.
Is not there.
But of course, there is a contradiction also, as pointed out by Lordship Ete. Now, if we leave out PW3, PW7 is there. 7, there is no PW7 is there, where there is no contradiction. 7 Lordship had seen. 7 Lordship will go to page 36. Down below, I visited the house of Krishna Biswas and Anita and asked them about whereabouts. Anita told me that he had visited and had gone away after collecting money. There is no contradiction as such. এইটো নাই, এই ধন বৰাই পোৱা নাই, কিন্তু বেলেগ এটাই।
No, you see, we are dealing with with an offense. I visited the house of Krishna Biswas and Anita Biswas and asked them whereabouts of Jan Bora.
Anita Biswas told me
Huh.
that Jan Bora had visited their house and he had gone away after collecting money from them. But then there is a contradiction again. Lordship
No,
will
it's okay.
find it at
You say Jan, they had, the time, the suggested time or
Ah.
date when he visited is not asked.
Yes,
So if
after 3-4 days.
no, miss, you see, you see, it's a vague question, and we are imputing a what you call sentence on a person on that. Because if I ask you, have you last time you visited my house? You will say yes. I don't ask you when you visited, because that would lead to a circumstance when my parents had died. You had visited the house at that point of time.
Of course,
No,
those
no, it's
precision.
not that.
Huh,
But to say that a crime has happened and you visited
huh.
at the proximity of crime, that is not a suggestion given. So whether that answer can be accepted.
Because in the facts and circumstances, we need details. We need precision.
I-
Like in PW3, as Lordship Ete pointed out, after the next day, in between the next day and the, so what is the time? Whether he had visited on 13th, 14th, what? These are not there.
No, not
And one more thing, of course, there is a contradiction also as far as PW7 is concerned, but that contradiction is not proved before the IO. Contradiction, Lordship will find at page 39. The last but one paragraph. I did not state in my previous statement before the police that after missing of Jan Bora, I went to the house of Krishna Biswas and Anita Biswas. Krishna Biswas and Anita Biswas told me that Jan Bora had visited their house and he had gone away after taking money from them. Here the contradiction is brought on record. But Lordship will go to PW8 then. This is not proved. PW7, not to that extent. Lordship will go to page 45. 45, last but one paragraph. PW7, Nituponi Bora in his previous statement for me did not state that on the next day of Pakua, father of Jan Bora visited his house and asked him about Jan Bora. This is not contradiction to that extent. So as far as PW7 is concerned, that part stays that they had gone, he had gone, and after collecting money, he left. These are only links to the circumstances. These are only links to the circumstances. If we brush aside PW3 being contradicted, PW7 statement stays. And the next circumstance, Lordship will go to the quarrel part. That there was a quarrel in the intervening night, on the night of occurrence.
No, it's a case, it's a defense of denial in, by the appellant in the 313 statement.
313, of course, I had to point out,
In
all
313, it was
this-
not put to him. Lordship.
these
It was
questions
these
were not,
questions were not
This
put
was
to
not
him,
put
that
to him.
this is went to his house. And once it is not put, that circumstance cannot be
It
relied
cannot
on. to
come.
complete.
at best, if we consider those circumstances as important as the links, then he needs to be questioned on that, then the case needs remand. That's an option that Lordship can take into account. If your Lordship thinks with the other circumstances on record that there is a case of conviction, or if your Lordship thinks it's not a case for conviction at all,
No,
Then
when
we
it-
will be-
no. When it comes to the proposition that I can think and find two answers.
yes. No, I mean, the Lordship reaches to the conclusion. Because if your Lordship reaches to the conclusion, the case is not made out, then sending it for remand and delaying Will not serve the
No, because
purpose.
now you can't improve, even if we send it.
Hmm.
We'll send it for what?
For 313, again, re-examining him from the 313 stage
So the evidence, whatever is there, remains on record.
will remain on record. Only from
Good.
313.
Nursing. Nursing.
Nursing, yes. Nursing is the judgment where 313, not questioning, incriminating circumstances and all are dealt with.
That's why yesterday I told you I'm in safe hands.
He remembers. We are from the same chamber. Lordship.
I learned from you only.
Lordship, I'm obliged, this is
where-
too much to say.
No. Where is a past tense?
Huh. Where is the?
Where, W-E-R-E,
Yeah.
is a past tense.
Mm. Yes, it's a past tense, which counts to a very great
It's,
extent.
it's only one factor, but not the relevant factor.
Very important factor. We owe everything to Mr. Mishra. So the next, Lordship will see the quarrel part. PW,
You know, the one of the good parts of sitting here, as a lawyer, you may find that somebody has argued a matter very beautifully, very well placed argument. But when the same argument is appreciated from here,
Mm.
then at times we find that perhaps the argument was nothing. Correct? So it's a change of perception when you change the chair, because
It happens at times. Yes. Mhm.
there's a very classic case of which had happened in Munsif Civil Judge number 3. A learned lawyer came to the court and said that my clients are here. So today I'll have to argue the matter. If your honor has to say anything to me, please say in English.
Ah.
Huh. And then his argument was in the court of Civil Judge number 3, sir, false statement, petition must be dismissed. Case number so and so versus so and so. All false statement dismissed. Today is the date fixed for so and so. Sir, false dismissed. Today I am seeking an adjournment for so and so reason. Sir, false dismissed. And then there is that the matter may be adjourned today. Sir, now we will have to take a decision whether to keep this petition or to dismiss it. And then he left.
These things also happen.
So the civil judge was dumbstruck.
Mhm.
What has happened? Incidentally, I was there. And he was very anxious that what has happened, why he was so angry, why so much of argument. What is wrong in this petition? What is there?
All because of the language.
No, and then I told him that his
No,
first
yes.
statement was that the
So
client was
will
there.
not understand. Client will not understand.
So he had to argue and did it. So that is the perception. So when it comes to where to carry it forward and bring it to a logical conclusion is means I'm not commenting on
Not Chip.
the chamber, but I'm only commenting on that there are various factors,
Various factors.
because here when we sit,
Mm.
we don't know you.
That is, of course, that should be the practice. That should be the these.
So that happens when when I put out my coat and this gown. Perhaps
Yeah.
then I'll
Back.
remember who are you.
No, this was on the lighter side, not to be taken seriously. So quarrel part, Lordship will see at page number with PW3. He said that on the intervening night, the villagers told him that there was a quarrel.
No, you see, first of all,
Mm.
all said and done, if there is a confession,
Mm.
you'll have to demonstrate that it was a confession which was made voluntarily.
Then there is no question of confession here.
No.
It's all before police. confession by accused is not the question here. I mean, here it, whatever accused said, it was before the police, that's not relevant.
Correct.
Huh.
So
These
if that
are-
goes,
Huh.
if that goes, and insofar as the question of this quarrel,
Huh.
or the fact that the accused was the deceased had gone to the house of the accused, those factors, I think it was required for the police to have this statement recorded under before the magistrate under 164.
They're not required. These are only links to the circumstances in order to show that they were there present together. That 164 recording by magistrate and all will not come in my humble submission, of course, subject to correction. These are only links to the circumstances. So there was a quarrel, and even PW 4 said there was a quarrel. The villagers said that there was a quarrel on that night. Till then, my problem is okay. But after that, after 7, 8 days, 9 days, the body was recovered. That, of course, the last scene theory has to be very short, so that nobody can come in between. Here, last scene is too long. But the time of death is also not reflected by the doctor. The doctor had only said that it is decomposed. So here we have to again go on some presumption that since all lungs, everything had decomposed, so the death was around 10 days back. So in between the quarrel and all, there was nothing, no materials on record. That body was recovered after 9 days on 22nd. And this was stated by PW 4 and 7. Thereafter, they brought the dog, they informed the police. Body was not recovered as led by the accused. That is no, there's no question. Brother and villagers were searching and they got the body. They informed the police. Police came. Thereafter, sniffer dogs were brought.
But the evidence of the doctor, the IO is totally different.
No, IO did not say. IO said the head was as
Mm.
led by the accused.
Come to page 44.
That perhaps will not be a correct statement. I've checked the case diary also.
It is not a fact that public had already recovered the dead body of the head of Bora before we reached their spot.
Before they reached the spot, it was informed to them. They reached. And then they brought sniffer dogs. Sniffer dogs took all the people to the house of the accused. Thereafter, accused was arrested on that night itself, 22nd. They were brought to the police station and so-called confession was recorded. Thereafter, since it was night, they did not go back. In the morning, 10:30 a.m. on 23rd, as led by the accused, the head was recovered. This is what I can show. Head was recovered. Lordship, it is in the statement of 2, 3, 4, 7, as well as the police, 8.
No, irrespective of the police, they say that we recovered it and the 2 policemen were there.
2 policemen were there. So,
Therefore, it is not a recovery by the police.
Police, as led by accused.
As led by him.
27 recovery, cannot be.
Cannot be.
27 recovery, at best, the head can, Lordship can somehow look into. Head. When they say, and all the witnesses have stated, that it was he who led the police and recovered the head, little near the place where the body was found.
No.
Lordship will see PW 234.
Just a moment.
Lordship can go to PW 8 straight, the police.
Just a moment.
Approximately 8 into all.
Okay.
Lordship has found that page number 44, the police have stated. Page number 44, the last paragraph. When I recorded exhibit 10 statement of accused Krishna Biswas, I did not record that he would show the shivered head of Jan Bora. No, Lordship, I'm mistaken. Page number 42. Page number 42, last paragraph.
It goes against you.
No, not goes against me. I'll come to this because there are decisions saying that recovery statement is always not necessary. If I can show it from the evidences on record that he had led to the recovery. In fact, Guwahati High Court judgments are there. Recovery statement, even in absence of discovery or recovery statement, 27 will be applicable. Here, Lordship will see 42, last paragraph. On 23/3 at about 10:20 AM, the shivered head of Jan Bora was searched at Kolong River in presence of accused Krishna Biswas, brother of Jan Bora and other local witnesses. The head was recovered on being shown by accused Krishna Biswas in Kolong River, which was floating on water. And there are other witnesses also who have substantiated that fact. PW 2, 3, 4, and 7. 2, 3, 4, and 7. And coming to the knife part, that was also led by the accused. Recovery of knife. Lordship can go to PW 1 once. PW 1 had stated page number 11. Page number 11. Page number 11, 4 lines from the top. On being shown and led by Krishna Biswas, knife used in crime was recovered from nearby his house. And the same was seized in my presence. And Lordship can also see from the other evidences, like I've just said, 2, 3, 4, 7, where it is said that head was kept in a concealed manner. So 27, one of the requirements is that the object should be concealed. So head was also covered with petaka and all those leaves. It was kept in a concealed manner. So knife was also recovered as was led by the accused. Even in the seizure list, it is written as led by the accused. I can just show it again. Page number 85. Page number 85. As led and shown by accused Krishna Biswas, which was kept in his house. Knife was recovered. Thereafter, even Lordship will see the chappal and the plastics were also recovered. These are only links which were near the headless body. And motive, of course, in circumstantial evidence, motive is required. Motive can only point out from 161 statement that they used to ask money from him every now and then. This is what is stated in 161. And 161, there is a strange thing. The 161 statement which is exhibited and the 161 statement which is there in the case diary is little different. Same day, 22nd, 7 p.m., 22nd of March, 7 p.m., 161 of Krishna Biswas was recorded by the police. There the statements, although the contents are same, few sentences are different. There he said, I can show the knife because that becomes a recovery statement. But in 161 statement that is exhibited, there he said, I have already shown, knife was already recovered. So, and the statement that is exhibited, I don't find it in the case diary. Case diary, Lordship, I'll just send it. Lordship can read Assamese very nicely. I'll point out this. Sir. Statement Ketuan Beleg Beleg. Ketu. Eya Krishna Biswas. And it was recorded at 7 p.m. Ketu Opobule afternoon. And there he said, last line also you see there. Dibo Parim. Moi etu no. Moi pulisok dekhwai dibo parim. And there it is written, I have already given. There is some difference. Another statement I did not find. Exhibitor to ase. But case direct.
If there are two statements that also again that benefit will go to because the IO has stated that he recorded the statement of accused only once.
Barring few sentences, other sentences are same. But here, moi dekhwai dibo parim. The knife.
Of Krishna Biswas.
Krishna Biswas. This was recorded at 7 p.m. on 22nd. It was 22nd day hoy. Eto. Eto moi data size 22nd hoy. Prime to night. Kintu ekhini je olop solop beleg. Even the first line, second line, those are different. Eneke nohoy ebo. Beleg beleg. Of course, benefit will go at that. I show everything. Lordship need not think that I will not show those things which are not favorable. I'll show everything. No, it's not that. Person should not be kept inside if he's innocent.
No, it's your duty.
It's my duty.
আমার করলে যায় It's a city.
Yes, only like that, like language.
Mhm.
Only like language.
Yes.
Not modern level.
I'm sorry, A2 Herito. Why? A2 decapitation is anti-mortem. It goes no, it agore kapi. Because after 9 days. The last sentence, Lordship will see, the knife I can.
দেখাই দিব পাৰিম।
Oh, here it's not the case. Here he said that it's already shown. I've shown it. It was deceased. Same IO has recorded. Head he doesn't say, but in this 161, I did not find that he can show the head.
Knife.
Knife only. So here motive, only one motive, some money part, body thing is there. And Lordship has also found in the evidence that
No, that motive we can't, at this appellate stage, we can't take cognizance of motive because in the trial court, that motive was never exposed.
But in cases of circumstantial evidence, it is the duty of the prosecution to show the motive. In ocular evidence, need not be. Here, and another factor, that was a day of Holi and all were drunk. So that was another circumstance. Like it can happen, quarrel happened, and then he dragged him and all. It can be a possibility. But of course, fact remains after 9 days, the body was recovered. There is every possibility that someone had come in between. And PM report, Lordship will find at page 11, where it is said decapitation was antemortem. So he was, perhaps was hit, he became unconscious, then the thing happened and he was cut. And as my learned friend said, I was asking him 6 inches, although the persons have said, they have only said by seeing it. So it can be 8 inches, it can be 4 inches and iron part, leaving the handle part. So that we cannot think, we cannot presume that it will not cut the neck. Of course, that needs sharp cut. That needs a big hit.
There also that argument can't be accepted for a simple reason. The reason is that when the Caesar memo says it's a 2 feet knife, then
with a wooden handle.
With a wooden handle, but let us take it, it is 2 feet. But when the evidence says 6 inches,
both of them have said. 2 witnesses, I think, have said 6
so
inches.
therefore 6 inches can't elongate the knife to. It's not acceptable that it's a knife of 2 feet.
So
And
these are the circumstances that
and the smaller the weapon, the harder it would be difficult to sever the neck. It's
Yes,
a
that
case of
is there.
severance.
but I have to prove homicide. Here, homicide, of course, he said that there was no injury except this decapitation. So that's the point which goes against me, because if I could have shown that he had in fact used a lathi, he had given a blow and he became unconscious, thereafter he had cut it or whatever. Homicide, otherwise it's proved, it's a case of homicidal death. It's not a case of anything else. It's a case of homicidal death. And whether these are the persons who are the perpetrators. And in order to show this, these are the circumstances. But I must admit, the time gap between the recovery of the body and the incident was too long. And there is no evidence in between in order to show that no other person had come in between. It was, of course, a village area. It was dumped in the river. It was all covered with the plants of those metacas. So these are the circumstances. Otherwise, I don't have any. That he was there was a quarrel, and then it was admitted by the accused persons. A body was recovered, sniffer dog was taken. They led to the house of the accused, and then they were arrested, and then the head and the knife was recovered. On being led and shown, there is a motive, and the PM report shows that it was a homicidal death, and the day was holy, and the people were drunk. These are the circumstances. If your lordship is satisfied, if it does make a change, then otherwise leave it to your lordship. These are my humble submissions.
Regarding that last scene theory which my learned friend placed before your lordship, that last scene theory, that circumstance was not put due to the accused. And after 6 years, it will not be a case to remand the matter only on that ground, because this is not a established fact. Had it been an established fact, that then it would have been different also. But and second thing, lordship, that PW3, which my learned friend relied regarding Onita, that is already proved, that contradiction is already proved. That was in cross-examination here. He was confronted with that, and IO was also confronted with that. That he has not stated before during investigation. During investigation, he has not stated that he got the information from Onita that this is went to their house. And apart from that,
Where is that?
PW3, lordship will find.
No, PW3, I remember, PW8.
PW8. Page 45. Middle portion, your lordship will find PW3 Dhan Bora in his previous statement did not state before me. Page 45.
Who is PW7?
PW7.
It's a four-villager.
Four-villager.
45, yes.
Yes, in middle portion, your lordship will find PW3 Dhan Bora in his previous statement did not state before me that while he visited the house of accused persons on the next day of missing of Jan Bora, accused Onita Biswas stated to him that Jan Bora had come to their house to collect money.
That is not, PW7 is
So
there.
that contradiction is already proved.
7 is
And
there.
apart from that, other circumstances does not prove that he is the person who killed the deceased. And knife, that is also not proof that it is the weapon of crime. Knife which was allegedly recovered, that is not proved to be an offense of crime. Weapon of offense. And only on the basis of last seen theory also conviction cannot be, person cannot be convicted. There is a judgment of Honorable Apex Court, that is lordship 2014 12 SCC 279.
Fourteen 12 SCC.
279. Paragraph 12, 21. And there is no material to show that the statement given by Onita Biswas is not correct. That the deceased left, that statement is not correct. There is no material on record. Even if we assume that Onita stated that the deceased took the money and left their house. There is no material to show that that statement is not correct. He had not left the place. Prosecution have to show that Anita stated a false statement, made a false statement. That part is not there in the record. And she is acquitted.
Yes. Yes. No. But Mr. A. Ahmed Lamed, amicus curiae, appearing for the appellant. As well as Ms. S. Jahan Lamed, APP appearing for the state. This appeal under section 374(2) read with 383 CRPC is directed against the judgment and order of conviction dated 18/3/2019, passed by the learned Additional Sessions Judge number 1 Nagaon in sessions within bracket capital T numerical 1 bracket close case number 51 within bracket capital N bracket close oblique 2017 under section 302 oblique 201 oblique 34 IPC. By which the petitioner was held, the appellant was held to be guilty of committing offense under section 302/201 IPC and was sentenced to undergo rigorous imprisonment for life and fine of ₹1,000 with default stipulation. And he was also sentenced to undergo rigorous imprisonment for 5 years and fine of ₹1,000 for offense committed under section 201 IPC with default stipulation. Next one. on '73, 2017, an information was given to the Koliabor KALIBOR police station by Srimati Juma JUMA Bora, wife of Jan JAAN Bora, to the effect that her husband was missing since 13/3/2017 and that his mobile was switched off. Full stop. The said information was entered in GD entry number 316 dated 17/3/2017 at 8 a.m. on 17/3/2017. Full stop. Accordingly, ESI Pinaki PI NAKI Acharya ACHRY within bracket PW1 was entrusted to undertake preliminary inquiry. Full stop. In course of investigation, on 22/3/2017, at about 11 a.m., the headless body of the missing person was found on column KOLONG river by the side of the house of a parents-in-law, namely, Krishna Viswas and Anita Viswas in a decomposed state. Full stop. Thereafter, the police arrested the appellant and his wife. Full stop. So anyway, on 22/3/2017, and headless, what is it? Headless body of so-and-so is recorded so-and-so. Full stop. On being led by the appellant, the head of the severed head of the deceased was recovered at about any time is given for recovery. Any time is given for recovery. Head
Head 10:30.
10:30. 10:30 a.m. on 23/3/2017. Just thereafter, the PW1, who is a police personnel, had lodged an FIR with the officer in charge of Koliabor police station on 22/3/2017, alleging that on 13/3/2017, at about 7 p.m., the deceased Jan Bora had gone to the house of his father-in-law, Krishna Viswas, and thereafter a quarrel over a monetary issue arose between the parties, between the appellant and the deceased. And it is projected that the appellant had assaulted the deceased on his head. And as a result of which the appellant had, the deceased had died. And the appellant, with the help of his wife, dragged and threw the dead body of the deceased in Kolong River. And the appellant had severed the head of the deceased by cutting it with a knife. And the head was concealed under Meteka in the river. On the basis of the FIR, Indian Packet Exhibit 2, Collier PS case number 39 of 2017 was registered under section 302 of the 201 of the 34 IPC, and investigation was carried out by respondent, PW8. Stop. No, who was then a circle inspector? Stop. In course of investigation, the IO had visited the site, examined witnesses, and recovered and seized a knife from the house of the appellant, with which he had allegedly chopped off the head of the deceased. And the statement of the accused persons was recorded. And thereafter, the dead body was sent for postmortem, and the investigating officer recorded the statement of the witnesses and prepared the sketch map and caused inquest report to be prepared through a judicial, through an executive magistrate. He's an executive magistrate.
Inquest, executive magistrate.
Executive
I've
magistrate.
seen the
Executive magistrate.
exhibit.
First of all, a legal aid counsel was appointed to defend the appellant. Let's go. Charges were framed against the appellant under section 302, 201 of the 34 IPC. And on being read over and explained to the appellant, he pleaded not guilty and claimed to be tried. First off, in support of the case of the prosecution, 8 witnesses were examined by the prosecution, and the following documents were exhibited. Next paragraph. Not expected, continuous, continue there. I is 77. 8 PWs and evidence, documentary evidence is 1 to 13. And material exhibits are A, B, and C, page 77. So. On conclusion of evidence, The appellant was examined under section 313 CRPC. And he declined to adduce defense witness. Next, in course of trial. Give a gap, this statement of witnesses, that will dictate later on. Next paragraph. You just listen to it because I'll be recording your statement. The learned counsel for the learned amicus curiae has submitted that that if the evidence of PW1 is to be believed, then the deceased was murdered by assaulting him on his head by a branch of a tree. Full stop. In this regard, it is submitted that the inflicting of head injury to the deceased was not proved by the prosecution. And that we'll have to rise. We'll continue the dictation tomorrow because I don't want to miss it out. When the dictation be in open court, then we can reserve it.
I'll just place one judgment on the issue that recovered disclosure statement is not required. I can give it now also, or tomorrow if your lordship continues.
Tomorrow? Monday, because tomorrow 18 cases have already been listed. Just. I'm sorry, yeah, for the amicus curiae for the appellant as Jahan done a APP for the state. The order is partly under dictation, which could not be concluded. So accordingly, list the matter again on 14/8/2023. You can give the citation now also. No issue.
This is 2000. I can read out the relevant paragraph. This is Muhammad Arif versus state of. It's not coming out now. One is Rajiv Fukan and the. In the Guwahati High Court judgment in that Rajiv Fukan's case, it is said that disclosure statement is not required, but prudence requires that it may be recorded because we not know what exactly what is discovered on being led by whom. So in that particular thing, it is said like that, but in the Supreme Court judgment, that is 2000.
Discussing the judgment from paragraph 23. Rajiv Fukan judgment is discussed in paragraph 22 of the Supreme Court.
Of the
Supreme judgment.
okay.
I had just taken out and now I'm not getting it. I'll send it, lordship, if your lordship
You
wants.
give it because brother have to rise. You have to be
Here,
sitting in another division bench.
Division bench.
Right.
I had taken out the judgments, but
It's
there's
okay. We'll take it.
and
We'll take
the
it on
Supreme
Monday
Court
also.
just said that it is not required. If there are enough evidence to bring into the home, to the home, that it is recovered on being led by so and so. Then disclosure statement is not required.
But that statement has to be disclosed by the IO in exact words. That is the I will also play that.
We'll take it on Monday.
Lordship, I got it, Lordship. This is 2011-13 SCC
2000.
or 2011-13 SCC 621.
621.
Muhammad Arif versus so and so, paragraph 68. And the other one, Rajiv Fukan, is 2009 2 GLT 414. That is Rajiv Fukan, where it is said prudence requires. Supreme Court doesn't say if there are enough materials. SCC, I'll tell you. নতুনকে use করছে যে, এটা আছে।
I'll be rising if anybody has to say, please tell it to the court master.
Okay.
Because my brother has to
2011-13 SCC 621.
rise.
May I please, your lordship? In item number
Tell it
6,
to the court master.
record
You have to break,
of list.
tell it to the court master.
Alright. मुझे हमला दिवाना से सिलेक्ट हो गई। हाँ। আল্লা হেৰি দাদা তেওঁ যে নোট আছে এটা আছিলে নি দাদা তেওঁ যে নোট লিখিছে এটা আছে নে প্যাৰাগ্ৰাফটো বটাই দিব পাৰিব
That's an apprehension, madam. And additionally, they have stated that they will take all necessary precaution at the time of dismantling that part, so that the main structure is not affected. And within a short time, they will do everything.
That may be recorded in the order, my lord.
No, it's already there, not necessarily, this order, honorable court order is there, we will not be violating that, once giving an assurance before his honorable
Then,
court.
my lord, what is there in my report?
Just because he has got an apprehension, we cannot be faulted, madam.
The petitioner also has to be satisfied. my lord.
No, but since they are saying it, will say that he is.
Yes,
referring to
we
the
go by,
attached
yes,
act.
madam, we will stick to that.
Be done. Because the problem is also another problem. Because if somehow it gets damaged, then perhaps he will not be able to make the same.
No, yes, of
Structure
course,
again.
that's why, Lordship may at one line, he will cooperate, at least
No,
on
we
that
will
day.
cooperate, my lord. but
Even,
that, my lord,
they have
what he has
stated, they have stated that, they will give a temporary shade so that the work is not obstructed, while road will have to, it will be used by the public.
Because yesterday Mr. Chaudhary was saying that if perhaps barrier is made and then it is constructed, then his house will not be
Yes,
affected.
my
That
lord.
is the only
Subsoil,
anxiety.
subsoil will not erode.
He's explained it to him. I
Yes.
did not
No,
understand
but,
that.
they have stated that they will do everything, yes. To
This
protect
is
it.
something I did not understand, so I asked Mr. Chaudhary to explain it to second Mr. Chaudhary.
But these are some things we also do not know, but my lord, in that case, I had a, my lord, indication that. is
No,
what I
but-
said.
Two Chaudharys together will understand more than
My what-
me in between. Mr. G. G. Chaudhary, counsel for the applicant. Was filed this, for the applicant, was filed this application for modification of the, of para 7 of the order dated 28/6/2023, passed in WBC 3755 of 2023. Next, the matter was listed on 9/8/2023 when an order was passed to permit the Learned Standing Council for the PWD to interact with the concerned officials and on the nature of prayer made by the applicant. Next, Mr. B. Gogoi, Learned Standing Council for PWD, along with Mr. B. Chaudhary, Learned Standing Council for PWD, has submitted that he has taken instructions on the grievance expressed by the petitioner applicant, and it is submitted that the
My lord,
PWD
we'll go by whatever has been recorded in para 5 of the earlier order. It is very much recorded.
stands by the contents of para 5 of the
Order dated
order dated
28/6/2023.
28/6/2023, passed in WBC 3755 of 2023. And accordingly, it is submitted that there is no likelihood that the main structure of the house of the petitioner would be
And my
affected.
lord, they will take all necessary steps to see, my lord, precautions to see that the building is not affected in any manner.
That we already read.
No, you see, they are not, they are only touching the veranda portion.
My lord, why I am saying, my lord, sometime before, there was a matter before this court, my lord. The matter was as regards, my lord, they stay under order 41 rule 5. There, my lord, after hearing the parties on the matter, it was a transfer of shares, my lord. Some decree had been passed. And when the matter came up, the order 41 rule 5 came up. Lordship directed that it will be secured by a bond, and all these things was told, and it was understood. Accordingly, bonds were submitted. Thereafter, the matter went to some other court, my lord. There, my lord, lordships in that court say that where is the stay order? So, my lord, until and unless, my lord, there is something, my lord, concrete there that we have seen, my lord, it was difficult on my part again to say, my lord. I said the tenor of the order says that there is a stay, and subject to the bond means that submit a bond, and on the basis of the bond that will be submitted, my lord, the operation of the decree will be stayed. That is the understanding, my lord. But then the counsel for the other side also suggests that no, this was not the understanding. So, my lord, if that objective, my lord, operative part is put there, my lord, then it will become final, my lord, and people will understand what is the tenor of the order passed by this court, my lord. That is my submission before this honorable court, my lord.
Anyway, it's submitted that there is no likelihood of of any damage to the temporary structure.
No, my lord, likelihood to the
Main
permanent
structure,
structure, main
permanent
building,
structure.
main building.
No likelihood.
Yes, no likelihood to the main building, not the
Not
temporary
temporary,
structure.
not
No, no, I am talking of main structure.
Yes, my lord. I had just heard, my lord, that it temporary
No,
order was
not temporary. The structure of the building,
my lord.
structure of the building. Because here I have clarified, temporary structure is not a part of the main building.
Yes, my lord.
yes,
Yes,
that
I
was
am saying that.
rightly
Yes, my
pointed
lord.
out.
Yes, we abide by that. my lord.
Next, in view of the submission made by the government, standing counsel for the PWD. As it appears that if the the PWD, well, it intends to protect the main structure of the building or the petitioner while carrying out their work.
By taking all necessary measures.
No, I'm not saying that. I'm not saying that because then it will be a matter of what is the
He said.
They are otherwise technically experts, they know how to protect it. They will do that. Only thing, madam, one line from our side, madam, that the petitioner will cooperate during those days, madam, when that part construction is started by the authorities.
Yes,
Some cooperation from us. You must, madam, trust us. That's
Trusting the government is very difficult nowadays.
এই দুদিনমান কিন্তু দোকান টোকানবোৰ
ঘৰলে অহা ৰাস্তা এটা দিবা খালি ডাঙৰ
কেইদিনমান আগত দিনৰ কাৰণে ওলাই যাব লাগে কেনেকে বনাব লাগে কাৰণ মাটি কিনিলে দিগদাৰ হয় ৰাতি ভিতৰত লাগিব সেইখন টাইমত
The knowledge request for the PWD is submitted
পৰা আৰম্ভ হৈছে
that the
তাৰ পৰা সেইখিনি মানত তোমাৰ নালাগে
with the
এক ফুট সেইটোৱে appearance হৈছে।
that the PWD authorities are only requesting the applicant to cooperate with them during the time when the actual
work is undertaken.
work is undertaken in respect of the structure,
Yes.
in respect of the building of the petitioner.
And the respondents will also take care, my lord, that nothing is happening to the building and they will employ all safety measures to protect the building.
Next, as the applicant is apprehending damage to the structure. It could be. It appears that it would be in public interest that the authorities. Mr. Gogoi, just hear this. It will be in public interest that that before testing the structure of the building, the PWD authority shall explain to the petitioner, to the applicant,
yes
the manner in which they will do the work.
yes
And they will take that all necessary precautions as he has said, my lord. He has said
No,
that,
no.
my lord.
It's not that. No, I'm making it now more clear
My lord.
that they will show you
Explain.
what they are doing.
My lord. And the
Because I'm
Because
writing, I'm making it very clear that they are not touching your structure, except for that
yes
my lord,
part which is being acquired.
my
Obviously, they will not be touching the structure except the part which will be acquired.
my lord, here the apprehension is not the touching, my lord. They will not touch it, my lord, but because it goes very near, my lord, while the excavation work goes on,
yes
that subsoil may erode for which that, my lord, structural.
It will not, they'll explain it to you.
they will do that my lord. In fact my lord, there is a NEPCO guest house in that area same my lord, we have to do the same job my lord there. It has been done immediately my lord.
No,
Same road.
if
They
Mr.
will do
Chaudhary
it. They are aware of this manner. They are technically expert. They will.
Mr. Chaudhary's explanation, just tell them.
Yes, they are
that
apprehension. Obvious. Everybody will have such apprehension.
Because today it is his house,
Naturally,
tomorrow it may be
they-
my house,
yes.
day after tomorrow it may be your house.
Yes, lots.
So only that.
They will do that.
communicate.
And then when he is not on that side, he is on this side, then again, he will also experience the same apprehension, my lord.
No, that's what I am saying. That's
No,
what
no.
you take care of it.
Naturally, my lord, everybody.
Because Mr. Gogoi and Mr. Chaudhary is never disappointed, not in me.
No. I don't say that. I have not said that at any point of time.
They never disappointed me.
In fact, before even filing this, I had talked to him. He
Yes.
said, my lord, he had assured me nothing will be done. But thereafter, my lord,
Client-
my lord, they come all the time, my lord, very senior person, my lord, comes and says, my house will go, my house will go. So I have no option but to bring this on record, my lord.
It's okay.
Lots.
Accordingly, this with the aforesaid observations, this inquiry application stands closed.
Moreover, what happens, my lord, when some link is there to Tezpur, then when some link is there to Tezpur, then my lord, people from Tezpur also starts, my lord, ringing up that he is that, he is that, he is that.
Because in